morning, ladies and gentlemen. I'd like to call to order Ventura County Planning Commission. If you'd please rise and face the flag. Place your hand over your heart and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. My apologies. I have a cold. I'm not trying to do a Barry White impression up here. I can tell how old the crowd is. They know who Barry White is. All right. Madam Clerk, if you call the roll, please.
Commissioner McGee?
Here.
Commissioner Aducas?
Here.
Chair Wessner?
Present.
Commissioner Rodriguez?
Here.
All right. The next item is public comments. This is the section set aside for items not on the agenda. Any member of the public may address the Planning Commission. However, under the government code, all we can do is receive the information and ask general questions. We would have to refer it later. Do I have anybody that wants to speak on? Thank you. Name and address for the record, sir.
Sure. My name is Mark Trinidad, 4690 Del Rio Court in Camarillo.
Thank you.
I apologize. I have to leave this public hearing this morning, so I'm going to comment on item 7, if I could.
Since it's agendized, how soon do you have to leave, sir?
Within probably the next half hour, 45 minutes.
What's the commission's pleasure? Take the testimony?
Yeah.
I appreciate it.
Okay.
Thank you.
Just understand, because where you're at, it creates a conflict for us to do anything with your testimony, but just receive it.
Understood.
Thank you.
Thank you. Again, my name is, good morning, Chair and members of the Planning Commission and county staff. My name is Mark Trinidad. I am Chair of the Camarillo Workforce Housing Task Force, which is one of the city groups of the Ventura County Farm Workers. This morning, I wish to comment on item number 7 regarding a density bonus. I also, by day, am a senior project manager of Mini Mansions, which is a nonprofit housing and service provider based in Thousand Oaks. As a developer of special needs housing, I've relied on density bonus law to achieve density that makes special needs housing financially feasible. Special needs populations require a unit mix that is typically more studio and one-bedroom units, apartment units, versus 2 to 3 bedroom family units. Hence, special needs projects, by design, have more total units. However, the total number of residents will often be smaller than a typical apartment complex, which is made up of 2 to 3 bedroom units. Thus, more units are needed on a special needs project in order for a special needs project to be developmentally and operationally feasible. By not allowing density bonus on the residential high density zone, limits developers' ability to deepen the affordability and target our most vulnerable special needs populations in the county. That's my brief comment. I thank you for this opportunity to speak, and thank staff for diligently pursuing the approval of the HCD of the housing element, the county-wide housing element. Thank you.
So you support the approval of the element?
I'm sorry?
I'm sorry. Do you support staff's recommended actions on the element?
Sure. Oh, this one, I'm sorry. Can you hear me now?
There you go.
Is that better?
I'm just trying to, are you in favor of the staff's recommended action?
I'm in favor in terms of the recommended amendments to, however, with the comments to those.
Okay. Right. Any other general?
To the density bonus not being allowed on residential high density zones.
Okay. Any other general questions? If you have additional comments that you would like to forward to staff so they can include it in the record.
Absolutely.
All right.
Thank you.
Thank you for your time, Mark. All right, the next item on our agenda is, as soon as I get there, approval of the minutes of August 15th. Commissioners?
Move to approve.
Second. Any additional comments on the motion? Not hearing any. All those in favor say aye.
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 Oh, we got to do the vote thing. All right. So, Paul, you were the mover?
Correct.
Okay. So you got to click the button.
Oh, yeah.
Okay. Rick.
Back up.
Rick.
Wrong button.
Rick, hit second for me. We have motion. Hit motion again, will you, Paul?
Okay.
No, hit
There we
second.
go.
All right. All right, we ready? All right. All done? It's not coming up on our screen either. Do you have it, Denise? All right. We have new technology and old fingers. All right, item number 6 on our agenda is this, Thomas Aquinas College, PL 12-0161, and they don't provide your name on the staff report up here. So please introduce
Charles
yourself.
Anthony.
Thank you. Please.
Good morning, members of the Commission, Chair. My name is Charles Anthony. I'm a planner. Excuse me, I'm nursing a cold as well. I'm a planner with the Ventura County Planning Division. Thomas Aquinas College submitted an application to the Planning Division for continuation permit for nonconforming uses and structures in the open space zone. The college requests to continue its operation beyond the 2027 expiration date of its current conditional use permit or CUP. Project is located, close to the microphone. Project is located north of the city of Santa Paula. Project, of course, is the college and the existing college itself, and also east of the city of Ojai, and also adjacent to Highway 150 and the National Forest, which is the Los Padres National Forest. As you can see in the site location map, the subject property owned by the college is within approximately 130 acres. It's 2 legal parcels. It's, as I mentioned before, here Highway 150 runs right down here. This is a shot of, as I said, in the entire campus, and shows the oak trees to the west. It shows the campus core, and then shows also all within the open space zone. And in this photo here as well, the adjacent areas are also open space. This is a shot, an image that shows a good image because it shows the college and how it's nestled in the open space, and it's surrounded by the Los Padres Forest and also the mountains surrounding areas, open space and agricultural area within the vicinity, near vicinity. Also, just to let you know, there's this is the access that hikers can take and then go up in that area up into that part of the forest. Provided by the college, provides public access to the hiking trail that leads into the National Forest. This is a campus core diagram. Shows, just to give you an idea of what actual buildings are out there. It's Faculty and Services building. Again, these are existing. Classroom building. There's a lab building. Commons building. There's the residence halls. These residence halls, there's 6 total of them in here. And then coming down here to the library, chapel, and in that kind of aqua blue color in the large arrow pointing, those are the site of 2 future buildings. One will be a second classroom building, and the other will be the site of a future lecture hall. Site area photos. This is what's known as the gatehouse and the college entrance. And the main entrance, if the daily use is really for visitors and staff and students, is this entry over here. This gate arch is really as a lead-in to the president's house. This is that I was mentioning that hiking trail that the college provides public access on its private property in order to get to the Los Padres National Forest. This is a shot showing where the first existing classroom is right here. This is what I would call the campus plaza area. And then we're currently under construction, and we'll see another photo of that in a minute, but it is the classroom that's under construction right now is the second classroom building. And then behind it, just a little bit farther west, will be the site of the future lecture hall. That is not under construction at the moment. This is just a shot to show you in the interior of the existing classroom building. This is one of the classrooms. This is a view of the lab building. The curriculum includes things like natural sciences, mathematics, philosophy, theology, and music. And so, of course, accordingly, the college has a lab building for its lab use for the students. This is a shot showing the construction of current construction right here, and the foundation excavation being for the second classroom building. In the distance here, you see the library. This is the arcade of the library, and then back here is, of course, attached to it is the library itself. This is a shot of the interior of the library. And then you can see the Commons building here. Inside the building is a cafeteria, is like a large dining area as well. There are some rooms there's a room for like a coffee house, and a little rec room, ping pong table, some area with instruments, so if the students want to play music. This is just a sort of a long shot showing, I believe I got all 6 of the residence halls in here. This is a close-up view of one of the residence halls, just to give you an idea of what they look like. Okay, just moving along here this is a shot starting to walk into the athletic area, athletic fields, and then here is the back of the library. Okay, this is if just taking a 180-degree view south, looking at the athletic field, you can see the enclosed water treatment plant in the distance. And this is the water treatment plant itself. The treatment plant takes care of about 50,000 gallons of wastewater each day. The water tank, this is part of the on-site well water system that they have providing for the college and its needs. History and background. In 1977, the Planning Commission approved conditional use permit CUP 3609 for the construction and operation of Thomas Aquinas College, or the college. In 2010, the Board of Supervisors considered and adopted an ordinance amendment, number 4411, which rendered the college use legal nonconforming. And the reason for the board's decision is that the college and universities were considered inconsistent with the clarified purpose of the open space zone. As part of that amendment, what the board did was it clarified and added in detail what the open space purpose was in Article 4 of the zoning ordinance. And to show you that, then rather than going into every detail of what that clarified purpose is, it's on page 2. I summarize it of the staff report, excuse me. And it says that the provisions of open space include protecting and preserving natural resources, protecting places, features, and objects, managing the production of resources, providing for outdoor recreation and public health and safety, defining and confining urban development, and providing additional buffer zones to military activities. With that clarified purpose in Article 4, the zoning ordinance, the board realized that the colleges and university uses, as well as 4 other uses, were not considered consistent or conforming with that clarified purpose. Therefore, they were essentially removed from open space as an allowable use, but were allowed to continue under their current CUP. And as I show here on the slide, college currently operates as a legal nonconforming use under its current CUP 3609-2, which will expire in 2027. In the project description, the applicant's request and the description of the project a little bit further, the college requests approval of continuation permit pursuant to Section 8113-5.4 of the Ventura County Non-Coastal Zoning Ordinance. This section allows for the continuance of a non-conforming uses and structures if certain standards can be met. The continuation permit will be for a period of 55 years from the date of permit approval, if approved by your commission. And the continuation permit will allow for 350 students and 50 faculty and staff personnel. These next slides just show, excuse me, in detail what existing structures and buildings exist out there today under the CUP that would be included by the new continuation permit if approved. The continuation permit, if approved, would be the governing permit and would supersede the previous and the existing CUP. These are just shown. These, the number of structures existing, which are mostly built, except for a few that have not yet been built, approximately 300,000 square feet of structural space, more than 30 different buildings. And the plans. The campus master plan, of course, is part of the permit and essentially is just a diagram showing what you've already seen before in the previous pictures. This would be where the sewage treatment plant is, wastewater pond. Here is the campus plaza area, and here, these are the residence halls. That water tank that I discussed earlier is out over here. An environmental review. In 1977, the Planning Commission certified an EIR that evaluated the environmental impacts of the college's campus master plan. CEQA Guidelines 15164 state that the lead agency shall prepare an addendum to a previously certified EIR, EIR if some changes or additions are necessary. In this case, the change would be the continuation permit, where it would be requesting an additional 55 years of operation. But if none of the conditions described in the CEQA guidelines have occurred, then a supplemental EIR would not be necessary. So, because none of the conditions described in the CEQA guidelines have occurred, and those conditions basically have to do with any new, if there was a new significant environmental impact, or if there would be a more severe intensity of an existing significant impact. In such cases, then a supplemental would be necessary. None of those cases were found after looking and doing a review environmental analysis of the project. Therefore, an addendum seemed to be the appropriate document to prepare. Okay, and the findings. Section 8111-1211-E of the zoning ordinance has to do with continuation permits for nonconforming uses and structures. And the next section, as mentioned before, an earlier slide, 8113-5.4 of the ordinance has to do with continuance of nonconforming uses and standards. Structures has to do with the standards. Both those sections the project was found to be in compliance, could meet those standards, so therefore all findings can be made. That discussion is detailed in the staff report, of course. Public notice. Of course, notice was placed in the Ventura County Star, was mailed to property owners within 300 feet of the property, and cities of Santa Paula, Ojai, and other applicable agencies and service providers were noticed as well. As of the date of this hearing, no comments have been received. And the recommended actions. The Planning Division recommends that your commission certify your review and consideration of the item, that you approve the addendum to the EIR, make the findings to grant a continuation permit based on the entire record, including the staff report, grant the continuation permit subject to conditions, and specify the clerk of the Planning Commission be the custodian of the record. And that concludes the PowerPoint presentation. If there's any questions, I'm of course available. Thank you.
Before we proceed to questions, disclosures. Paul?
No disclosures.
I recently visited the campus, and I also read the U.S. World and News Report that stated that the college was the counterpart to UCSB in terms of being a party school. And also, I spoke to someone last night who reminded me about a problem that occurred in the past regarding people leaving their cars in that parking lot and using the hiking trail. And I wanted to ask if that was an ongoing problem or whether they figured out a way to survey that parking area.
Commissioner, is this in regard to the on-site parking or off-site parking?
It's the one that visitors use in order to access the site. I'm not sure if it's because I never had a problem going there. I'm not sure which one, this is just based on the conversation
Sure.
I had last night, so
Sure.
I don't even know if it's factual.
Well, yeah, and there is some little spots, little turnout parking spots directly across the street, and a little bit south that I did notice, and I think also north on Highway 150 where people can park. I have not received any comments. I haven't heard anything formally. I don't know if the college staff wishes to.
Okay, but now this is just disclosures right now,
Right.
so
Okay.
so I needed to disclose that because I was going to ask about that.
Sure.
All right, now you're prepared. I have no other disclosures, but I'm just familiar with the property over the last 30 years.
I'm also familiar with the property. I've been there and been up that hiking trail quite some time ago. I'm glad to see public access is still very well maintained.
Okay. All right, with that, any questions of staff at this time? Just a little bit later, I will be asking about, under the EIR from 77, I believe it's page 39, the effluent storage ponds as a mitigation factor, a capacity of 75 continuous days or 1.5 million gallons of sewage effluent. What I'm going to be asking is later on, has that become an issue over the last few years? Or because your report says there's been no complaints, all conditions have been met. But I just want to touch on it because that seemed to be the significant thing from that report. Okay, but then we can handle that later. All right, ladies and gentlemen, I always make this disclosure for those of you who are not here for the college. If you parked over here in G, it's a 3-hour limit. So I will try to remember around 10:30 or so to remind you, because the county will ticket you. All right. If you have a cell phone, please place it on silence or turn it off. Now, the procedure that we follow here at the county is the fact that now the staff report has been given. The applicant is allowed to speak. Then we open a public hearing. Those in favor of the recommended actions speak first. Those who oppose will speak after. The applicant then is allowed any rebuttal time that's appropriate. And then at that time, if the commission wants to close the public hearing, we will do a follow-up questions of staff and then deliberate. All right. With that, I have one card from the applicant, Michael McLean. Please state your name and address at the podium. And if you have nothing to say, that's perfectly fine too.
Okay. My name is Michael McLean. I'm the president of Thomas Aquinas College. I live on the campus at 10,000 Ojai Road, Santa Paula, California. I want to begin by thanking the planning commissioner, planning director, the planning staff, and county council for the care with which they've considered our application for a continuation permit. They've been very judicious through this whole process, and I think Mr. Anthony's report speaks for itself in terms of the detail and the careful analysis they've given to the college's situation. Since the Board of Supervisors passed the zoning change amendment in 2010, which had the perhaps unintended consequence of rendering Thomas Aquinas College a non-conforming use, we have been concerned on the campus to try to reach an arrangement with the county that would ensure both ourselves, our future students, our benefactors, our alumni, that the college indeed can be a permanent resident of Ventura County and that we're here for the long haul. You can see from the campus, we've invested considerable resources in developing the campus, and I think the college has proven to be an asset to Ventura County and to the world of higher education at large in the United States. So this morning I would just like to speak in support of Mr. Anthony's and the planning staff's recommendation that the commission approve the 55-year continuation permit. I think that would speak to the college's permanence and to its importance in the educational community. And I would also like to say that our long-term goal remains to reach an arrangement with the county where the college would be a legal and conforming use. So we plan over the next period of time, in consultation with the planning director and staff and perhaps the folks from SOAR, to look at alternative ways in which the college might be in a situation where we would be legal and conforming. And that would, I think, solidify our relationship with the county and be a great consolation to us who are responsible for the school, knowing that we're here legally, that we're a conforming use, and that we're permanent. I would just, if I could, address Ms. Adukas's comment. When you said counterpart of UCSB as a party school, I hope she meant we're the exact opposite of UCSB as a party school. So we were actually rated, I think, one of the driest campuses in the United States.
Exactly so.
Yeah, there we go. Okay. All right, I appreciate the opportunity to speak. Thank you very much.
Just a minute, Mr. President. Any questions of the President at this time?
Are you familiar at all with past problems with people breaking into vehicles of hikers?
Yeah,
Did that occur on campus? Or?
Well, we've had occasional problems with break-ins and thefts from college vehicles, student vehicles, or faculty vehicles on the campus. They've been isolated, and for the most part, the hiking public has been very good about restricting their parking to locations that are off the campus. I will say that on a typical weekend, there are probably 50, 60 cars parked along the edge of Highway 150 on both sides of the college entrance. I don't think that's the best situation. But as far as we're concerned, the relationship with the hiking public has in general been pretty good. So we're not...
Has the college been impacted, or has it taken steps to address anything that might be a danger to
Well, I think in recent years, it's fair to say, maybe Mr. DeLuca could address this better, but we have increased our security presence on campus. We have security personnel on site over the weekends in particular. That's when the heaviest traffic occurs. And I think they've been successful in directing the public to the perimeter road, which is the county-approved and the college-approved access to the National Forest. And in general, the hikers have been very good about restricting their usage to the perimeter road. Occasional folks will cross the campus property, which we discourage. But in general, I think we've been able to manage the situation pretty well.
Okay.
Is that fair, Peter?
Yes.
Yeah.
Okay, again, I don't have firsthand knowledge of this. This is secondhand from somebody I spoke to just last night. And then just for background, you've been there since 1977, and what's unique about Thomas Aquinas College as opposed to other small colleges?
Okay, I could tell you the long story or the short story. I guess the short version would be that we have a single fixed curriculum that all the students follow. We offer one degree, which is a Bachelor of Arts in Liberal Arts, so we don't have majors or electives. And our students all study using what we call the great books of Western civilization. And all of the classes are conducted as small seminar-style discussions. This class size ranges from about 15 on the low end to maybe 18 or 19 on the upper end. And the goal of the college is to engage the students in a serious discussion of the most important books that our civilization has produced. And we're also, of course, a seriously Catholic college, so an important, very important part of our curriculum is the Catholic philosophy and theology that we offer our students, and of course the spiritual life on campus. You saw the picture of the chapel. That's a center point of the campus. So I guess our Catholic character and our commitment to discussion style teaching and the use of the great books and that single fixed curriculum are what sets us apart from almost every other school in the country.
And how selective are you? Are you full at 350 or?
We are. We manage our admissions by taking a maximum of 102 students into each freshman class. And then over the 4-year period, there's always some attrition. So we usually end up with an average of enrollment of about 350 students. But we do it by managing the freshman class. And in recent years, we've accepted full classes into the freshman year, and we anticipate doing that going forward.
Thank you very much.
Okay, thank you.
Commissioner Radke.
Mr. McLean?
Yes.
I was reading the staff report. Says the college has indicated that it will seek to exclude the college property from future SOAR boundaries, thereby eliminating the SOAR requirement to place the college's request on a countywide ballot. So when you spoke a moment ago about trying to get conforming status as opposed
Yes.
to non-conforming status, is
Yeah.
that what this means here?
Well, I didn't hear exactly what you read there.
Well,
What-
basically it says that you want to be excluded from SOAR. So is that through being...
I think that's fair to say. I mean, we're doing this in consultation with Kim and other members of the planning staff. As I say, our long-term goal, I think, is to secure this 55-year permit, and then try to find a way where the college could be, in virtue of its kind of obvious permanence on the site, become a conforming use in terms of the Ventura County land use statute. So I think that does involve discussions with SOAR and trying to get, if I understand it right, a certain kind of carve out from the SOAR restrictions so that the college would end up being a conforming use, although still in open space. I think that's my understanding of what we're trying to do. Yeah.
Have you talked to anybody from SOAR yet?
We have. We've had a meeting, at least one meeting with the leadership of SOAR, and they seem very amenable to our concerns and responsive, and I think they've actually encouraged us to remain in contact with them as I think the SOAR initiative is up in front of the voters in 2019 or 20, something like that. 2020, and they've urged us to remain in close touch, and we intend to do that and work with them to see if we can't get some kind of carve-out or exception for the college on the next ballot measure.
Thank you.
Nothing for Mr. McLean, just a general comment. I am familiar with Commissioner Dukas' concern about problems with vehicles, and it's an ongoing problem, as the President states, primarily on weekends. It's not unusual to have multiple vehicle vandalism or break-ins there.
For the benefit of the public, how do you know this, Rick?
My past 10 employment,
And that would be?
Ventura Sheriff's Department.
Thank you. Don't want any ex-party information coming in here. All right. That's general knowledge. Any other questions of the President? Again, do you accept all the conditions and requirements that the staff have written into the conditions?
Yes, absolutely.
Okay. Thank you very much, sir.
All right, thank you.
All right, I do not have any other speaker cards, either for or against this conditional use permit. Is there anybody in the public who would like to comment at this time? Let the record reflect there was no one, so at this time, the applicant has a right to rebut what was just said. Therefore, I assume there's no rebuttal. So we'll go to staff. Mr. Anthony?
Okay, excuse me again. In regard to your question, the mitigation measures on page 39 of the EIR were from, as of course you're aware, were from the Environmental Health Division back in 1977. And those, of course, were concerns with groundwater quality safety, as well as proper treatment of effluent and wastewater and sewage. And so a list of these details were directed at that time. Of course, this was over 30 years ago. Since that time, there have been some changes to the wastewater treatment plant. There was a modification. I don't have the information in front of me at the moment. There was a modification. There were changes. The Environmental Health Division, for review of this project, had a chance to review it.
Okay.
They provided condition number, I'll provide that in a moment, which is attached to Exhibit 6. Thanks, Dan. And which is a septic system. And what basically the Environmental Health Division said is they are giving the primary responsibility for regulation of the on-site sewage treatment to the Regional Water Quality Control Board. And in so doing, and considering that, I have correspondence from the Water Quality Board that states their full responsibility for protection of ground and surface water quality. They had a chance to review the project. They had no comment. They did not identify any new significant impacts.
All right, thank you. That's what I was looking for. Since there's been a lot of changes in the last 30 years as far as water quality.
That's a very good question.
Okay. All right. Anything, other questions of staff at this time? Madam Director?
I'd just like to put on the record that, Thomas Aquinas College has been very kind to the county staff during this time. It was an item that was it was unintended by the fact that the county was challenged on having assembly type uses in the open space zone, but we clearly knew that it would affect 5 uses. And so they have a current permit until 2027, right? But they're being proactive in the approach to come in to the option that was afforded to them. So we knew there would be 5 uses, and so we built in the continuation just for these specific circumstances. And they have been very kind and generous. Mr. DeLuca I've worked with for years, and Quincy, and obviously Dr. McLean, been very nice to work with. They were put in an unusual circumstance, and they've worked with us very well to try to maneuver into an eventual conforming use, and everybody, I think, is trying to work towards that goal.
Okay, since you brought it up, I'm going to go through that question. The reason I'm doing that, the public hearing is still open, and I want to discuss that. We obviously had a challenge not too long ago in the Tierra Rojada Valley with an application, and one of the representations was St. Thomas. And that created us a little bit of difficulty, both from SOAR, open space, religious non-conforming, those kind of things. I understand this college has been a great neighbor. I want to get staff's feel on moving forward, if we should approve this, the ability to deal with these other entities that may forward and cite this college as a precedent. Have you had that conversation amongst yourselves, or?
Yeah, clearly we've had that conversation, right? I think that they do have an end use, right? They are a non-conforming use, and they have an end use to their permit, and that is the way that the law works, and so that's the way it is. So we've put some thought into the 55 years that were given. They had a 25 and a 25-year permit before, so they had a 50-year permit before. So we're continuing that 50 years and allowing them a 5-year time horizon to build out the other 2 rather major structures on their university. But the bigger issue that we really tried to lay out in a meeting with them, and in our letter to them of July 17th, which is the Exhibit 8 to your staff report, is the ultimate solution for them. So, we are aware of any precedent setting. We did think carefully about the timeline. They do have a timeline, right? It's a 55-year permit. It has an end date to it, and that's really what we needed to do.
Well, the conversations about RLUPA and those issues that came along. So, all right. Any other questions of staff before I close the public hearing? Hearing none, the public hearing is now closed. Commissioners, what is your desire on this matter?
Move staff's approval. Staff's recommended actions to approve.
Okay.
I would second that.
Okay, so you got to hit the motion on the floor. You hit the second, please. Okay, any discussion on the motion? I want to thank the college for being a great neighbor and participating with us, and sorry that you get caught up in the process. But all those in favor, please vote aye.
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 Click the little green button. Anybody dare to vote no? Incur the wrath of powers beyond us? Just a comment. Thank you. Congratulations. You have been approved. If anybody opposes this, you have 10 days to file with the county your appeal. All right. Let's take a few-minute break because we have to change some staff personnel. But, gentlemen, thank you for coming in. The best of luck to you. We'll take a... Everybody set? Welcome back to the Ventura County Planning Commission. We are on item number 7, housing element updates. Staff.
Good morning, Mr. Chair, members of the Commission. I'm Kari Finley, and I'm the project planner for this item. This project or item actually consists of 2 projects, which is the update to the 2014 to 2021 housing element and updates to the density bonus ordinance or density bonus provisions of state law. Let me get this going. Okay, our objectives for today are to receive a staff presentation, listen to public testimony, review and comment on the 2 draft documents, and then direct staff to forward recommendations to the Board of Supervisors for approval. I'm going to, since this includes 2 large projects, I've broken the presentation into 2 separate items. And I'm going to cover first Article 16, the updates to the density bonus ordinance, and then pause for public comment and deliberation, and then move forward into the second item once that item's been acted on. Forward to the housing element. Okay, so part 1 is going to be about the density bonus ordinance. To start off, I wanted to provide some background. And the current density bonus regulations are found in the county's non-coastal zoning ordinance in Articles 16 and 19. And these 2 elements or 2 sections of the non-coastal zoning ordinance are currently outdated. There were revisions to state law in 2005 and again in 2009 that provided a lot more specificity about density bonus provisions because it's very complicated, as you can tell. And even though our ordinance hasn't been updated, the state law prevailed through this period, and we have not had any requests for density bonus during that time period as well. So we really weren't in jeopardy of any of issues. We just defaulted to state law. This has been a program in the housing element for since the last cycle, and moved into this newer cycle with 2006-2014 housing element. And we're now processing it concurrently with the housing element update because the HCD, which is the State Department of Housing and Community Development, reviews our housing element. And one of the provisions they have for a streamlined review of your housing element is to have an updated density bonus ordinance. So I spoke with their staff, and they agreed to allow us to process it concurrently, provided that the density bonus ordinance gets adopted first. So we are moving this forward rapidly, trying to meet our housing element deadline. So it's very critical that both these get approved concurrently or in sequence in a very close time period. And then just for the context of that, if our housing element isn't adopted within the time frame, we have to revert to a 4-year housing element period. But if it is adopted within that time frame, we get an 8-year planning period, which would be good since we just went through an update 2 years ago. You may recall I was here in June 2011. So these are the provisions and the differences that were in our current non-coastal zoning ordinance and the differences that the state law required for update. And I'm going to briefly talk about them, and then I'll get into more detail as I get into the provisions in the sections of the proposed ordinance. But these are new things that are being updated. Eligibility requirements for density bonus, density bonus in ranges up to 35% that depend on the amount of affordable units that are provided. The number of required incentives, again, I'll explain what each of these different things are, but just to get familiar with the nomenclature, I wanted to lay this out. waiver requirements, reduced parking requirements, and modified requirements for senior housing, and then also density bonus for land donations. So these are all new things that have been incorporated into our proposed density bonus ordinance. So I want to note, too, those are all mandatory provisions, and you'll see here, this is a summary of what those are. If a applicant proposes affordable housing, they are entitled to be granted density bonus increases, density increases in their project over and above what the zoning allows for affordable housing guarantees for 30 years or more, senior housing projects, and then condominium conversions, which is the conversion from apartment to condominium.
If I could stop you right there, there's also another area, the mobile home conversion, using the condo conversion. If you don't want to answer that right now, but address it a little bit later. Okay. So
Okay.
just put that thought in your head.
Okay.
Thank you.
Then other mandatory provisions include incentives and waivers, which are modifications of or reductions to development standards, and then again the reduced parking requirements, and these are all mandatory provisions. So some non-mandatory provisions that we've included that I'll explain in more detail are some location and phasing and design type development standards that have to do with the location dispersal of units, phasing of affordable units and market rate units in a mixed project, and then standards for exterior appearance. Other provisions that we've added through discussions with Ms. Mafia-Ortiz and include this additional density bonus for projects that are 100% affordable. And what we're proposing is up to a 15% increase above the mandatory 35%, not to exceed 50% density bonus on projects that are 100% affordable. And I'll talk a little more about that in a minute. And the maximum, again, would be 50% total for those projects. So now I'm going to get into some of the details, kind of section by section, and because it's so technical, I'm kind of taking it apart and trying to explain how it works. It's a pretty complicated state law, and we tried to mimic the state law, so it looks pretty legal in the draft, which is shown as Exhibit 2 in your packet.
Okay, we also got an exhibit about errata on some of the language. You're going to include that at this point, or are you going to discuss that a little bit later?
Let's see. The errata is related to the housing element.
Okay.
So I will discuss that when I bring up that
Okay.
second item.
Thank you.
Okay. Okay. So our primary goal, again, is to update these provisions to be consistent with state law, but also to get this adopted. And so we've used this format where it closely mimics what the state law says. This shows, well, also one more time, back up one more time. What we've done is we've taken Article 16, which is our current density bonus for senior and low-income housing projects, and then Article 19, and what we're proposing is to repeal those and reenact them combined as Article 16. So what I'm talking about is the new Article 16, and it combines the senior and low-income housing provisions of Article 16 and the updated provisions of Article 19, which is our condominium conversion density bonus provisions. So just to get that straight. So our proposed ordinance is divided into 12 sections. Obviously, I'm going to go through each one, but the title and purpose and the definitions are kind of self-explanatory, so I'm not going to get into details about those, but you can find those in your Exhibit 2. The first technical piece I want to explain is Section 2 talks about density bonus, and it begins by describing the types of projects that would qualify for density bonus. So these include housing developments with a minimum number of affordable units, housing developments with a minimum number of affordable units and a child care facility. They get an added bonus for the child care facility. Senior citizen housing, which needs to be a minimum of 35 senior units. Land donations, which means instead of building it on site, they donate land for an affordable project. And then condominium conversions for moderate income. This chart is in Exhibit 2 as well in the proposed non-coastal zoning ordinance. And you can see that the first line talks about, it has the different categories and what the proposed bonuses are for a household income category and a minimum number of units, the density bonus they receive, and then additional density bonus if they increase their minimum number of affordable units. And in all cases, the maximum is 35%. And I'll talk about the exception in just a minute. But let me just take, for example, the first line talks about very low income. So if an applicant comes in and has a project for, say, 20 units, and they propose to reserve 1 unit, which would be 5% for very low income, for a very low income household for 30 years, then they're entitled to the 20% increase in density bonus or an additional 4 units. So then the project would now be 24 units with 1 reserved for affordable. And to take this a notch up, I put this chart in here that says if they, well, we'll go back one more time. If to address this additional units, I'm going to show you how this works. So if they do 20 units and they propose to reserve 2 units for very low income, that's 10% of the original units, but the minimum number is 5%. So for the first 5%, which is the minimum, like I just mentioned, they get 4 units. But for the additional 5%, they get 2.5% per percent increase. So I'll go back here again. So that's right here, this 2.5%. And that means they get an additional 12.5% for that second 5% increment, which is an additional 3 units. It's actually a fraction, but you round up. So they get 4 plus 3 units, or 7 units of density bonus for providing 2 very low income units on a project of 20. Did you follow that? I know it's kind of complicated, but I wanted to make sure it was clear what the huge incentives are, and I think it's a pretty good incentive. This is actually a total of 20% plus 12.5%, which is 32.5% density increase. So they could even increase slightly more, up to 35%. And that's the maximum allowed by, or dictated by state law. Okay. So in addition to the 35%, staff is proposing, this is not mandatory, not required by state law, but in our discussions with our housing advocate, we've also included this additional 15% for projects that are 100% affordable, and that would go up to 50% maximum, which is the 15% over and above 35 for projects that are 100% affordable. There were some other provisions that were requested that we opted not to include, and I'll discuss those in a few minutes. So in addition to the density bonus, applicants for affordable housing projects are entitled to incentives. And these are also, the numbers are also dictated by state law, and that's what's shown here on this chart. These incentives are modifications or reductions in the development standards, such as setbacks or height or open space requirements or parking requirements. So again here, if we take the very low income first line, the minimum percent of affordable units, if they provide 5%, they're entitled to the 1 incentive. If they provide 10% of their project as very low income units, they get 2. Or 15%, they get 3, and then so on. And then just as a side note, the process that we're advocating would encourage the developer to come in and talk with the planning division staff prior to submittal so we can work out the details of which incentives work the best or appropriate and why they need them so we get a good project. Because basically what this law is doing is taking away a lot of our zoning requirements and saying it's just clearly incentivizing affordable housing development. So in addition to the density bonus and incentives, an applicant can also request a waiver of development standards. And the waiver, there's a fine line between the incentives and waivers, except that the waiver is something that is going to have the effect of physically precluding the construction of the development with the density bonus and with their incentives. And if they've, say, for example, gotten, a setback deviation or front setback or a side setback and an open space deviation, but they come in and they say, I still can't fit this density on this site. The site is just too small. I need to add another story. They can request a waiver. And, that's just an example. There could be all different types of permutations of which is an incentive and which is a waiver. But they're entitled to this. We can't preclude the project from being built because of our development standards. And then there are also findings that we must make if we're going to deny either an incentive or a waiver. So the fifth section talks about mandatory, again, parking modifications. And these are the ratios that are dictated by state law. So if this includes both handicap and guest parking. So if they have a 0 to 1 bedroom or studio or 1 bedroom, it's one space. Or 2 to 3 bedrooms, it's 2 spaces. And then 4 or more is 2.5 spaces. And that, again, is what we get. And as an incentive, they could request further deviations from this. And that would be one option of an incentive. Okay, and then this is the one I mentioned earlier about one of the non-mandatory provisions that we included is found in Section 6 of the proposed ordinance. Includes location dispersal of units, which would encourage them to be dispersed through the development. Phasing, that when the project is phased, like if we're going to build it in 3 phases, that a proportionate share of the affordable units are built at the same time as the market units. And exterior appearance, so that they should be constructed of similar materials to have a good project. We recognize that the location dispersal, we are not requiring these, but they are preferred options that the staff is including because we recognize that location dispersal of units, many times affordable projects, they have to have a separate lot to get for their funding purposes or a lease. So it may not work in all cases, but we want to have a cohesive project, if you will. Okay, then Section 7 talks about the application requirements. Any project that comes in is subject, the density bonus provisions are kind of a separate piece of these projects, and any project that comes in is required to apply for either the tract map or the underlying plan development permit, depending on what the request is. If they're asking for a subdivision or a PD permit in the RPD zone or whatnot, that is still a discretionary project. The part that is mandatory is we can't use the density bonus as a means to disprove this other project. There has to be other findings or reasons that the project is disapproved or not approved. But in addition to their completed application for their underlying permit project, we are also asking for these other things to be included on their site plan and in their application materials. The number of affordable units, the location, and in the specific request for density bonus and incentives and waivers. This section talks about how that the project shall be granted unless these findings are made for incentives or waivers to deny them. The only way it would not be granted again is if the underlying permit application is not approved. It talks about compliance provisions that also would apply, such as conditions approval, has an housing agreement, an equity share agreement, which I'm going to talk about next, and then a recorded deed restriction for sale units. These projects are also subject to, just like other projects, they're appealable to the non-coastal via the provisions in the non-coastal zoning ordinance. So this section 9 talks about agreements, and then these are essentially the contract and what helps ensure, because we're tasked by state law to ensure that if they say we're going to produce affordable units, it has to be a minimum of 30 years, and these are the contracts, the vehicles that are used to ensure that that happens. And also it ensures about the senior occupancy for senior units. And while the senior units are not required to be reserved for affordable, they're required to be reserved for seniors. Okay. So there's the housing agreements, and then there's equity share agreements that applies to common interest developments. Common interest developments have to do with moderate income projects. It's specifically defined in the Civil Code what a common interest development is. It includes things such as community apartment projects, condominium projects, planned developments, and stock cooperatives. Well, and then just a little bit further, it talks about upon resale who gets what share of the equity, essentially, in very simple terms. Okay, Section 10 was previously found in Article 19 and deals specifically with the condominium conversion portions of the state law. If the applicant provides 33% moderate or 15% low-income units in their conversion from apartments to condominiums, then they get 25% density bonus or other financial incentives of equal or financial value, of equivalent financial value. This Section 10 also talks about meeting with preliminary proposals with planning staff, application requirements, the approval authority, all the similar things that I already talked about for density bonus. And it also specifies that they cannot get an additional density bonus if this project's already qualified under the density bonus provisions, and that's also in state law. Then Section 11 talks about implementation and enforcement. And this just reinforces what the county's authority is to enforce the terms of the agreements. They're subject to audits to make sure that they're occupied by the appropriate people, and then the county or the designee has the authority to enforce. So now that I may have you entirely confused, in Exhibit 8 of your Planning Commission packet is this chart. It's a little hard to see here, but it kind of simplifies what the roll-up of what a density bonus allows, what the density bonus provisions allow. Here, this first column shows what the applicant needs to provide. And if they do so, the second column shows what they get. And so we call these non-discretionary provisions. That means the state law mandates these. So everything in the top shaded box is mandatory by state law. And so if they are qualified for a density bonus and they provide one of these, they get that increase in density, plus they get, if they still are qualified, they meet these density bonus provisions, they also get incentives. They get 1, 2, or 3 based on the number of units and the affordability level. And then they also are eligible for a waiver. Then down below here under discretionary provisions, we call them discretionary because these were not mandated by state law, but it's something that we added in for the 100% affordable projects. And then again, all projects are subject to their the underlying discretionary development permit, except in the RHD zone, which you may recall when we updated the housing element last time, we did the rezoning program for RHD projects, which is done with a RHD zoning clearance, and it's a ministerial process. It's not something that we're allowed to deny. We can talk about the design of it, but not the project itself. All right. So I want to give you now an overview of our public outreach efforts. We conducted public workshops in November last year for the housing element, and we also had a segment for preliminary concept ideas regarding density bonus. We've had things posted on the website, the drafts and the hearing notices and workshops, and we also have a Twitter account now. In June and July, we posted the draft on the website for public review. We also met with and discussed in detail the provisions with our housing advocate, Ms. Macri Ortiz, and we've went through all of her concerns and had an in-depth discussion about each of those and why we did include them or why we did not. They are also all of our public comments from the workshops. There was a board hearing on the housing element. Those are also included. And then anything else that we received and the letter we received from Ms. Macri Ortiz are all included in Exhibit 7 and our response to those. So these are the requested, we call them non-mandatory options that we included, or not, and why. And we included the 100% affordable for residential development projects except in the RHD zone, which is number 2. We did not include it in the RHD zone because, again, this RHD process is ministerial. And so we've already done environmental review on those projects to make it ministerial. And by increasing the density beyond what the 35% density bonus already allows by state law, we felt that we'd have to reopen our environmental review and start over. And again, we're on this, these sites are already constrained. We looked at all of them in depth with an EIR the last round, and we just felt that that was above and beyond what state law mandated, and it was more than we needed to do. And I want to point out here, though, that the density bonus up to 35% does apply to RHD properties because they're required to be affordable projects, but we didn't want to include the additional 15% for these reasons, because that would go up to 50%, and they're already constrained properties. The other thing that was requested that we did not include pertains to additional incentives for 100% affordable projects. And as I was explaining, the incentives are, they already get up to 3 for an affordable housing, 100% affordable housing project. And, they grant deviations from all of our zoning, and the zoning is there for a purpose. And as we start to give more and more incentives, the density's been increased, and now we've, gone back on 3 of our development standards, and they're entitled to a waiver. So if there's anything else, once they've achieved their additional density and 3 incentives, and they just can't fit it, they can request a waiver. So we didn't feel like adding additional incentives really added value to the process. We also felt that it could compromise, I said on the second bullet point here, public health and safety, the quality of development, and the compatibility with the surrounding area. So last but not least, the CEQA documentation, Mr. Anthony explained to you earlier about what an addendum is, and we prepared an addendum for this primarily to address the increase in density because that wasn't addressed for the RHD zones, and did the full analysis, and it's included as Exhibit 4. And our findings were that there was no substantial evidence to warrant preparation of a subsequent EIR or a subsequent MND. Essentially, there are no additional impacts or mitigation measures that would apply. Then that brings me to our recommendations. They're in your staff report. I'm not going to read through all of them, but essentially we're asking that you certify that you've considered the report and all the exhibits and the EIR addendum, and that you make adopt a resolution to recommending approval to the Board of Supervisors of the proposed density bonus ordinance, Article 16, updates to Article 16 of the non-coastal zoning ordinance. Let's see. One thing I didn't talk about, we received one letter regarding density bonus. It had to do with, it just came in last night. It came from Habitat for Humanity, and I believe they're here to if you have questions for them. And they were requesting that we look at adding provisions so that the density bonus ordinance would apply to projects that are 4 or fewer. And the state law specifies 5 or more. And we've, again, when I talk about zoning and what this law does to our ability to regulate land use, it becomes pretty onerous. And, I mean, well, pretty flexible, I guess. And 4 or fewer it's just a different, it's intended to be towards larger subdivisions and multifamily residentials and projects and the state law. And the 4 or fewer just is not, we didn't include it, and we didn't feel that it was applicable in this case. So that was a new issue that came up, and we are not recommending to modify anything, particularly to stay on track with our timeline. If it was something that wanted to be considered, we would need to do that at a future date, if it's even doable. So with that, if you have, we've published in the local newspaper. We did, I sent out, I think, 110 email notices to interested parties, and we've met the requirements of public noticing. So if you have any questions, that concludes my presentation.
Okay, before we go to that, we have to have disclosures. Commissioner Maggie?
No disclosures.
I have no disclosures.
Unfortunately, I have disclosure, but I don't know if it's relevant, and I'll leave it up to County Council. I am the General Counsel for the Housing Authority for the City of Santa Paula. The only reason I bring this up is that we do participate in some of the grants and loans that are made available through the county. I am not the decision maker, but I do advise, but it is only within the city limits of Santa Paula. So I personally don't feel there's a conflict, but I'll leave that to the judgment of County Council.
Thank you for the disclosure. There's no conflict.
Thank you. Commissioner Rodriguez?
No disclosure.
Thank you. All right, any questions on density bonus at this point in time?
What I
Good.
did is I went through and highlighted, and there were just general questions on the staff report and some of the exhibits. So they may or may not just be confined to the density bonus ordinance.
All right, well, I'll tell you what then. Why don't we let staff proceed, and then you can do the jump. I too have the same issue.
Okay.
Did you have any questions? All right.
Mr. Chair?
Yes.
Yes. In some cases, there's very few nonprofit affordable housing for sale developers. And so they take up a small niche, if you will. Mm-hmm. And so what would it take to get a waiver for an entity like that? I mean, if some of these 20-acre parcels out there, what if one was donated to them? They couldn't do anything with it, except sell it, I suppose. What would it take to provide a waiver for an entity like that in this process?
And you're talking about Habitat?
That's one example, yeah.
And well, specifically to Habitat, they tend to, and I'll let them speak for themselves, but to my knowledge, they generally do smaller projects that are maybe one or two duplexes, and they're typically small lots in infill areas. And those projects are also another avenue they could take is a variance request that would allow them to request a deviation from the development standards as well. It is a discretionary process that needs to have full review, but again, we didn't look at that issue as part of this draft, and so I don't, my gut feeling is that for smaller projects, I just don't know how that would work, or if it works, or if it's supportable in accordance with the statute.
But they could go through this variance request process and see what happens.
Yes.
Okay, thank you.
All right, any other questions of staff at this time? If not, Ms. Finley, please proceed.
That completes my presentation on density bonus. So I thought I was requesting that you would take this project as its own at this time and have your public comment and deliberations at this time.
All right, Commissioner Rodriguez.
I have one question related to density bonus as it relates to parking. What we saw up there is the state standards or recommendations.
It's a mandate, yes.
Okay. It just seems a little, well, given the world we live in today and the transportation available in this county, it seems like it's inadequate, and that's just my concern.
Okay. I'll tell you, it's going to be a little different, but I accept. We'll go ahead and take public comment, open the public hearing on the density bonus. I know there's some people in the audience who want to discuss a lot of other things. So what I think the commission will allow is you're going to be welcome to come back later on, because then when we wrap this all up, because staff recommended actions are bundled.
Well, actually, we separated them out in the back of the staff report. So it has action 1 and then action number 2, I believe, is how it's worded.
Okay.
So you could take this action separately.
All right. Let me take a look at that again.
Action 1, Action 2. Might
Let
say
me-
action.
let me-
No.
Yeah.
Let me find how it's worded. That's not the exact words. So the recommended actions 1 and 2 pertain to the density bonus ordinance, and then the recommended action starting with 3 pertains specifically to the housing element.
We still need to hear public testimony.
Yeah. Okay. We're looking at what we have in our packet here. Okay. I see. Okay. I see what you did. While we're looking at this, County Council, I'm a little concerned that the recommended actions are not clear on how they're bifurcated. Any comments?
You think what specific recommendation?
Oh, it's just, we're looking at our recommended actions, which was produced to the public,
Correct.
right? Okay, and I see what she's saying, the fact that under F, recommended actions 1 and 2 are to certify and adopt relating to non-zoning, sorry, this cold's getting to me, zoning ordinance. And then item 3 is adopt a resolution regarding to the amendments.
Yeah, I believe staff just felt it might be easier to process this separately.
Okay.
I don't think that's mandatory. You proceed in that way.
Okay, thank you. Again, we have to work on what's been provided to the public. So, commissioners, you want to move forward just on 1 and 2?
No.
You want to do
No,
all?
I think that we need to open up the public
Oh, no,
hearing
we
and
won't.
get, yeah.
Yeah.
I mean,
All
if we need to vote it separately, that's fine, but
Okay.
we still need to hear the public.
Everybody comfortable? All right, thank you.
And if I might suggest, and County Council might want to weigh in, is perhaps you want to take testimony on just the density bonus, because if we wait till the end, I have another long presentation about housing element. I don't want the issues to get all confused. It just might be simpler, but that's at your discretion.
Right, why don't we do that? I don't see 200 people out there, so I think we have the
Okay.
flexibility of time here. All right, then I'll go ahead and open up the public hearing. Those that wish to testify, I understand you've heard the dialogue up here. We'll bring you back if necessary, okay? All right, thank you, Ms. Denny.
Okay.
Appreciate it. All I'm going to call you in the order which I received the cards, which is our protocol. So we only have 5. So we'll start out with Susan Johnson, followed by Steve Dwyer. And when you come up, please state your name and address and what you think.
Good morning, Planning Commission. My name is Susan Johnson. I am a longtime volunteer for Habitat for Humanity, but I am here today on behalf of House Farm Workers of Ventura County. I am also your former Chief Deputy Agricultural Commissioner for the county. I live in Fillmore, and I chair the Fillmore Farm Worker Housing City Group. I'd just like to make some initial comments about agricultural workers, just to kind of remind you who we're trying to house here, in my case. Thank you very much for allowing me to comment. We have a kind of a unique situation here in Ventura County, considering that we are adjacent to one of the largest metropolitan areas in the country. We have a remarkably healthy agricultural economy, and that depends heavily on agricultural labor for its economic viability. We're in a situation right now where we have a critical shortage of agricultural labor. We have crops that have, some of which have gone partially unharvested because we have such a shortage of agricultural labor. Most agricultural workers are at the bottom of the economic ladder due to low wages, in many cases intermittent work, and for that reason they often live in crowded and substandard conditions. I'd just like to point out some of the contributions that these people make to all of our lives. They provide us with a relatively cheap and abundant supply of locally grown produce. They're essential to sustain the farms that make this area so desirable to live in. Farm workers are essential to the quality of life that we all enjoy with its lovely view and its small rural towns. The agricultural economy in Ventura County is worth well over $1.5 billion in 2012. Low-growth ordinances have passed in almost every city here in the county, except Port Hueneme, which is entirely surrounded by Oxnard, and Ojai, which has even stricter standards than the rest of the county. The view and the open space are impossible without a viable farming economy. Farmers are price takers, not price makers. The price of produce is not generally set by the local farmer, but by an interaction of brokers, buyers, and shippers. So much of the produce that we grow here feeds the rest of the nation and the international economy also. But because we enjoy an abundant and comparatively cheap food supply, farm workers often need subsidized housing. And the point of all this is, which I'm sure some of you have heard before, I apologize, is that with the density bonus, we're often up here saying, yeah, we need that 1 or 2 more dwellings. But that 1 or 2 more dwellings that we get sometimes makes a difference between a viable project and a non-viable project. And these projects literally change the lives of 50 people at one time. It's amazing how much difference you make in somebody's life because you put them in a clean, affordable, decent place to live. So there's just a couple things. We'd like to commend the county for their hard work and generally honest approach to the housing element. We think that this is an honest effort to move affordable housing forward, and we thank you for that. But while the county has agreed to allow a discretionary density bonus of 15%, for 100% affordable, this density bonus is not allowed in the residential high-density area. We would like to see that density bonus allowed in the residential high-density. We think that this is an opportunity for the county to move this forward. The bottom line is that most of these projects will likely need to be built in residential high-density areas because that's where you build them. And the other issue is the criteria for granting an additional density bonus is akin to granting a conditional use permit. It requires a finding by the decision maker that the additional density bonus requested would not render the proposed qualified housing development incompatible with the character of the surrounding legally established development and would not be detrimental to public interest or public health and safety. Obviously, we have no problem with public health and safety, but the incompatible with the character of the surrounding area, this pretty much opens the door for automatic denial because our projects are always viewed by the neighbors as incompatible with their community character. I have never advocated for one of these projects where there wasn't somebody up here saying, we don't want those people there, we feel like this is going to ruin our neighborhood, we feel like this is going to ruin our quality of life. So we would prefer to have it based on health and safety and based on more tangible ways of declaring a project incompatible. We believe that the only burden on the applicant is to show that the application of the development standard would physically preclude construction of the project at the density or with the incentives permitted under state density bonus law. Once the applicant makes this showing, we believe that it would be to your advantage to waive the development standard unless you can make a clear finding that it violates health and safety or some construction or federal standard. Thank you very much.
Any questions of Ms. Johnson at this time? Thank you. Steve Dwyer, followed by Barbara Marcy Ortiz. Name and address, Steve.
Yes, Steve Dwyer. I'm the Executive Director with Habitat for Humanity in Ventura County, and I live in Thousand Oaks, 717 Russian Creek Place. Okay. And so thank you, Commissioner, for the opportunity just to say a few words. And let me start up and be very clear. I'm in no way opposing the density bonus. I did want to point out, and we sent a letter in yesterday, and I appreciate some conversations I had with your planning staff, that one of the uniquenesses that was pointed out about Habitat for Humanity is that sometimes we do larger projects, oftentimes we do very small projects because the parcels that are available that might not be appropriate for other providers of affordable housing are very appropriate for Habitat, which works on a model of building homes alongside families where we offer 100% affordable homes, and we do it on a model of home ownership. So families are selected, they work alongside our volunteers, and then they pay a no-interest mortgage over a long period of time and eventually will own their home. We think this is a very important aspect of providing affordable housing in Ventura County, but it puts us in a unique position as it relates to the particular process in place here because of the five-unit restriction. So we're not opposing that, but I did want to point out to the Commission this kind of unique position because, as I understand, if a project were to come up where, for instance, we might have a small lot where we could say, instead of 2 homes, we could put two duplexes on. That would still fall under the 5, and we would fall into the waiver process within the county, which we would certainly work towards, but we couldn't avail ourselves of some of the modifications and incentives that are embraced in this document. So I just wanted to make that comment. We have built 56 affordable homes in the past 20 years. This is our 30th anniversary for Habitat for Humanity in Ventura County, and you might be proud to know we are the oldest affiliate in the state of California. So we do see ourselves as an important aspect of building affordable homes here, and we do want to thank the county for tremendous support over many, many years for Habitat and our Habitat families.
Any questions of Steve? I have one.
Yes.
Okay. Since you've been at it this long, how many of these infill type projects specifically do you find within the county purview as opposed to within cities? And the reason I ask that, in the study that I read here of the county, there wasn't a whole lot of places identified outside of a city limit or sphere of influence. So what is your experience been?
I've been in this role as executive director for 4 months. I'm not going to be in a good position to answer that question, but if I could check with my colleague Milt Redant here, who has led our site acquisition process for many years. Did you hear the question, Milt?
Yeah, I think so.
Bill,
the main area,
name and address.
Milton Redant. I've been head of site acquisition and Habitat for a number of years and on the board.
Thank you.
The main unincorporated area that we've identified with over the years is Pyro. Mm-hmm. That falls under your jurisdiction here. And some years ago, we had a big project there, built 20 homes off the main street. So that's one project we had. That was one of our initial endeavors. And then about 2 years ago, we completed 2 homes more in town. So that was the extent of it. The original project some 10 years ago, and then the last couple of years, 2 more.
Okay, thank you. Appreciate it.
And you're right that I would consider these sort of exception types of comments. I guess as I read the document, it will be in place for many, many years here. So we just wanted to make sure we just made the point that we fall into a niche category. I think that that's a fair term relative to some of the affordable housing providers.
No, and I totally understand. That's what we're trying to do here is take a big collage, if you will. And but as Ms. Johnson testified, when it comes down to that one person, it's significant. And it's making sure that we don't decide here to recommend something. 5 years from now, it comes back in front of us, and our hands are kind of tied. Right. So anyway, thank you for your testimony. Barbara, followed. Name and address, please.
Yes, good morning, Chairman Wesner and Commissioners. My name is Barbara McAfee-Ortiz. I live at 1121 West 1st Street in Oxnard. I'm an affordable housing attorney. I represent a number of affordable housing developers, as well as I'm on the executive committee of House Farmworkers. I really appreciate and want to thank the staff and Assistant County Counsel Linda Ash, because we did spend some real quality time going through the ordinance, trying to make it as good of ordinance as possible. I kind of look at it as this is the manual, sort of like if you're trying to fix a car, you need a manual. And I do a lot in terms of helping nonprofit developers in particular and some other developers in trying to get their projects through the planning process. And I actually have been consulting with a lot of different developers around the state now on a number of issues that we kind of ended up being cutting edge here because of the problems we had in the county. Not the county incorporated so much as jurisdictions in the county. And so to kind of step on your, the idea of we don't want to tie the hands, okay? And I was looking at this ordinance specifically to make it functional, workable, and foreseeing issues based on my experience. And so that's kind of where I'm coming from. And I wanted to give opportunities. And starting with the additional density bonus, and I really appreciate the staff's willingness to incorporate it. The only problem is that it's being incorporated everywhere but the one area where it would be most likely used, which is the higher density, because that's where you're going to get your best opportunity to build affordable housing. We're not going to build it on a 10-acre site. We need some high-density sites. Now, I was thinking, okay, how can we maximize it? And I also understand your issues in terms of, okay, yeah, these sites are challenged. We went through that with the housing element, and I understand. We're there because there really wasn't anything else, but they're not great. And, there's the bets are out as to whether any of these sites will get developed. I, commended Supervisor Bennett in saying, well, we want to do this for affordable housing. Let's limit it to that. That's very creative solution, and I support it. So now the question is, okay, what are we going to do in these sites? And the language that I submitted, which is it's my comment 4 on page 17 of your, I guess, the staff report in that exhibit, 7 or whatever that exhibit is. I was looking at it, okay, I understand you can't go big in terms of, say, necessarily big families in terms of your housing, but I thought, use this as an opportunity to provide an additional tool to try to reach the housing for the people, the special needs group that are identified in your housing element, and the ones who really need the housing. And in particular, these are groups that generally their spaces are going to be smaller. So the language that I was proposing was where you had a development coming in that at least 20% of the units were for one or more special needs groups, including disabled, seniors, farm workers, single parents with children, emancipated foster youth, chronically homeless, or other special needs as identified in the housing element. And at least 10% of the total units were designated for families or households earning no more than 30% of the median income, that you would give this additional density bonus in the high density, on the high density sites. The chances of getting a project that'll do that are probably pretty slim. I'm not opening the floodgates. You're not going to be flooded with these projects because they're so hard. But as was stated both by Mr. Trinidad, Mark, who spoke during the regular initial public comment, and Ms. Johnson, that's the difference. Could be at one unit or that 2 units you can get, that extra 2 is maybe the difference between making that project work and not work. And so what I'm suggesting is don't tie your hands. If you accept this, you're not, like I said, it's not opening the floodgates. This is a challenge. We're lucky we can hit 1. But you don't want to have that one project that comes in the door where you can't give them that extra unit to make a pencil. And that's why that was proposed. And so I would ask you to consider that change, which the language is on page 17 of comment. It's comment number 4 at page 17, so that you don't miss the opportunity. Ms. Johnson spoke a little bit about the standard for the extra density bonus, using that kind of the CUP language, where it's incompatible with the character or convenience. I mean, that's one that every time we go up, that's the problem. Everybody says, oh, this is a great project. Just not in my neighborhood. It doesn't fit here for one reason or another. So on that side, I say, why make your job more difficult for yourself? Because the standard should really be the same standard, which is specific adverse impact. If there's a specific adverse impact that's objective, quantifiable, that's the standard that should be. And I believe the proposed language that I have on that is my comment number 5 on page 18, in terms of the language I would propose. But it really is, and see, under the law now, under the Housing Accountability Act, for actually denying a project, even where you're requiring a special use permit, if it's an affordable housing project, your reasons to be able to deny it are only those under Government Code 65589.5, which give you 5 reasons. And convenience to the neighborhood or incompatibility are out. So, again, look farther. Don't make it harder on yourself than it needs to be. In terms, one of the other proposals that I had was to add, give them extra incentives. I think they were very hesitant on that. It's a missed opportunity, but, I guess you have to balance there. That's comment number 7 on page 19 in terms of the language that I was proposing, in terms of if you get more special needs or you get higher projects, then, give them an extra incentive. Again, the ability to build these, especially now that the subsidies are drying up, it's very challenging. The biggest issue beyond that I had is with the burden of proof under the waiver. And it was interesting listening to Kari. She said that in order to deny a waiver, how did she put it? You have to make findings. So you have to make findings to deny a waiver. That's what she said. The problem with your language in your density bonus ordinance at 8116-4.1 is that they're requiring 4 findings in order to grant it. It's the reverse. And I know we have a debate. Okay, this is get two lawyers in the group, and it's amazing how much agreement we did have, okay? So I think everybody's working in good faith, but it is putting an affirmative duty to put on a record. When you have to make affirmative findings, when the statute says in order to deny, you have to make a finding to deny, not a finding to approve. And some of the things, it puts us in the situation of you have to make findings saying there is no, it's contrary to the law, or it's contrary to this, contrary to that. It's like, how do I put on evidence of nothing? It doesn't exist. How do I put evidence on? So that's really my concern there. But that's, again, I do want to commend the staff and the county in terms of the attitude. This usually in jurisdictions it's called hide the ball. The public gets the document, or I'll get the document, maybe 2-3 days before, and I may not even be in town, and it's a scramble. This way, we really thought through some things. I think we made some good changes that make it clearer and more functional, and we'd like a few more if you'd entertain it. Thank you very much.
Okay, any questions of Ms. Ortiz at this time? Okay, thank you. Mr. Perez, followed by Ms. Woodburn. I'd like to welcome to the dais the President of Ventura County College District Board of Trustees, Bernardo Perez. Name and address, sir.
Bernardo Perez, professional address 702 County Square Drive. I'm a project manager with Cabrillo Economic Development Corporation. And I'm pleased to see my good friend and neighbor from Moore Park, Chair Wesner. And I'll claim this all the time, former chief of police in Moore Park when I was on the Moore Park City Council there, Richard Rodriguez. Good to see you again. And good morning to all planning commissioners. Let me begin by saying that I too appreciate the transparency and cooperation of county staff. This is my first engagement into this process. Our CEO and real estate development director both have probably been participating. They are not available today, so here I am. But I'm pleased to be here because as a practitioner in the development of affordable housing, personally and Cabrillo organizationally, we've been doing this for over 30 years now, successfully, because we've been doing it responsibly. And part of that responsibility is to participate in the development of these kinds of measures, legislations. And then we live with it also, as does staff. And so I'm here to support basically the suggestions requested by Barbara Macri-Ortiz. We have a working relationship with her as well. But from the perspective of what we've experienced in some of our projects, and I guess I would like to say, why foreclose the opportunity now? There's enough checks and balances throughout the remainder of the process that I think any project will have to pass muster. And another perspective I want to share with you is as funding sources at the state and federal level and even at the local level are dwindling, we need to see what are the impacts on the remaining funding sources, and like the tax credit program and state housing programs are looking at more cost containment issues. Therefore, it's incumbent upon us to be more efficient with our design and construction and to be able to spread the costs across more units. We serve, so therefore that's why I'm arguing for greater flexibility, more units on these high-density sites. Also, to the suggestion that Barbara Macri-Ortiz mentioned about being able to carve out some allowances for special needs populations, I'm looking at, okay, if this goes through, what might that lead to a potential project for us? Because in the past we have done some mixed housing projects where we've had working families with farm workers with special needs populations. So keep that option available as this process moves forward would be my suggestion and request to you. That's it. If you have any questions.
Any questions? Commissioner Rodriguez?
I just do. I'm trying to remember in my many seatings at the city council meeting up in Moore Park. There was low-income housing built during the time I was there. Was that, as I seem to recall, it was either Cabrillo or Habitat out off LA Avenue. That was farm worker housing? Can you refresh my
If
memory?
if it was south of LA Avenue, that was Via Campesina.
That's
And it was-
that's it. Okay.
And it was primarily farm worker families that incorporated. Actually, they learned from Cabrillo's effort at Cabrillo Village. That's what introduced us to them. And yes, it was farm worker families, groups of, and Mike probably remembers this, families in groups of 10 helped each other build their own homes. That was a sweat equity project.
The sweat equity. Okay.
And thank you for asking that, because again, I remember at the time it was somewhat controversial because there were some concessions needed, and this is way before, legislation that's in place today. But people didn't know. Okay, what would be the impacts of certain concessions on this kind of a project? And I maintained then, and I'm pleased to see that still, that this would become one of the jewels in Moore Park because people were personally invested in that development. And once people moved in, they brought their trades and craft and enhanced their properties beyond what was provided in the initial development. So again, it was because that openness, that flexibility was provided for that we ended up with a good thing for all.
Any questions? Just one. I'm going to ask the same one I asked of Mr. Dwyer. It's been your experience since you're in the acquisition side of it. Mm-hmm. And I'm coming at this specifically because of the counties. Most of the opportunities I'm seeing is within the cities and not a lot out in the county, which is where we're going to have the effect with this documentation. What's your experience currently or in the past as far as county? I know Piru is one of the areas.
A lot of our activity, as you know, has been in local community, local jurisdictions. Right. But we do have an eye for those potential opportunities. Mm-hmm. I mean, the county has been a great partner just with the affordable housing industry here locally. I mean, they've made changes in their SOAR and provided mechanisms to develop farm worker housing in county land. So it's been limited, to be honest. Mm-hmm. But we're monitoring this kind of activity to find out where might those future opportunities lie. And let me just comment again on the description of the high density sites as being constrained. Well, that's been our challenge all the time. We end up with not the best sites, but with creativity, with cooperation, with flexibility, we've been able to utilize some of those less premium sites.
Mm-hmm. Okay, thank you. That's pretty much been my experience too. All right.
Thank you.
All right. Ms. Woodburn? Housing. Okay, thank you for. Then I will let you go first on the next one. Okay, that's on the density bonus, commissioners. Did you want to vote now? You want to take staff presentation on the housing element? What is your desire?
Let's move forward with staff development.
Okay. All right, then we'll reserve the decision making as far as 1, 2, and 3 at that point. So, Ms. Finley? I tell you, let's take about a 3-minute break. I need to do something with my throat so I can continue this. So give you a little time to collect your thoughts. Okay, when you last left us, we were about to go to part 2, the housing element. Ms. Finley, you're up.
Okay, here we are, part 2. So this pertains to the update for the 2014 to 2021 housing element, and then there are some other related general plan amendments. So on behalf of the housing element team, there is a team of us that's been working on this for a long time, that I'm pleased to present this to you. I first want to acknowledge the efforts of my assistant planner here, Jennifer Choi, who did the lion's share of the work on this land use update, which is the technical appendix, the land use appendix update, and it's full of all kinds of data, and she scrambled and scrambled for months and did a really good job putting all that together. So I wanted to acknowledge her because she doesn't get to come up and present it. Okay. Okay, again, let me start with a little background. The current housing element was adopted in June 2011 by the board and certified by HCD, which is the State Department of Housing and Community Development that oversees housing elements throughout California. And they certified it in October of 2011. This update is to comply with Article 10.6 of the California Government Code that specifies a mandatory update within specific timeframes. We are now in what's called the 5th Regional Housing Needs Assessment Cycle, which is what RMA stands for. You'll hear me talk about RMA a little bit later. And that period, or that cycle, is from January 1st, 2014 through October 15th, 2021, and that's specified in state law. If we meet our deadlines for adoption, and I'll talk about that as well, we will have a new 8-year planning cycle versus the previously, well, it would revert to a 4-year cycle if we don't meet our deadlines. So here's the process. It starts with the SCAG, the Southern California Association of Governments, Regional Council approving the RMA. Sorry about all the acronyms, but that's the nature of this. And that happened in October 2012. And then we brought a draft forward to the board in February 2013. They reviewed the draft, and then we sent it to HCD for a streamlined review. And I spoke about that briefly with regards to the density bonus ordinance. One of the requirements to qualify for the streamlined review is to have an updated density bonus ordinance. And since we were working on it, we gave them an administrative draft and said we're going to take these in tandem, and they said that they accepted that. So we're trying to keep it on track. And then in May, we received a draft complaints letter from HCD, which means that they reviewed our draft based on the streamlined qualifications and felt that it complied with state law. So we're moving it forward, but the reason it's taken a couple months is because we turned and focused on the density bonus ordinance and worked with the public members and put the draft out for public review and focused on that for the last couple of months. So right now we're at our Planning Commission hearing, and we have a hearing scheduled in front of the board on October 22nd for approval, and then we'll submit it to HCD for a final review and hopefully get our certification. Again, we want to continue to qualify for the streamline review. Okay, the organization of my presentation. First, I'm just going to talk about the organization of the housing element, and then what we're actually proposing. I'm going to focus in on the key points of the update, and then related mandatory updates to other elements, which is our safety element, and then what we did for public outreach and hearings, our CEQA documentation, and then our recommendations. So the first item is the organization. Our housing element is made up of 2 key components. That includes Chapter 3 of the Goals, Policies, and Programs document, and then also the technical appendices, which includes all this information about housing supply and inventory and things that are mandated by state law. The technical appendix in our case is called the Land Use Appendix. The first document is organized into 4 chapters: the general Goals, Policies, and Programs, Land Use Designations, and then the chapter we're focusing on is 3.3, which is Population and Housing. And then we have a program in Chapter 3.4 that pertains to jobs and housing balance, so we include that with our housing element update. The Land Use Appendix, you can see, is full of all kinds of data and information, and I'm not really going to get into the details of that. One chapter I will focus on later is Section 337, which is our inventory, and that's a key component. I spoke about the RMA, or the Regional Housing Needs Assessment, that's assigned to us, and the inventory talks about how we can comply with those housing need numbers that are given to us by the state and then SCAG. Then this is the Chapter 3.4, and these are the subsections, and again, it relates to the housing element in the terms of jobs housing balance. It's not necessarily, we're not doing a whole update to that chapter. We just look at updating the parts that are pertinent to housing. So now I want to get into what we actually did for this update. I'll talk about some of the process and the critical components here. Let's see here. Okay, I already mentioned that the planning period will be 8 years unless we get it adopted by the deadline. Then it'll revert to 4-year. So here's just some more information for laying the groundwork of what we did to update it. The primary thing I want to talk about are the programs. And what those are the actions that the Planning Division is directed to take to implement the goals and policies. And the goals and policies are pretty much predicated on all the data that we get and how well we're able to meet our inventory and other state law requirements. So I'm going to focus on the programs because those are our action items for the next 8 years. The first thing I'll talk about, I'll call them accomplishments, are the programs we completed in the last cycle and since then, which is now the density bonus ordinance has been the biggest program that we've put into motion since the adoption in June of 2011. The second element I want to talk about are other programs, such as ongoing programs that are carried forward from the previous housing element and that are also things that we just do routinely, like updating and monitoring and reporting and that type of thing. Continued programs are additional programs that we're bringing forward that have a specific time frame associated with them. And then we have 6 new proposed programs, and a couple of those were actually recommended that we add them in by HCD, by the state, when they did their streamline review. And then the third item I want to talk about in regards to the update is what our inventory is and what the regional housing needs assessment was for Ventura County. So these are the primary, just to roll up of what some of the accomplishments were, the major accomplishments of our last housing element that we brought forward 2 years ago. We rezoned for emergency shelters. We made changes to the non-coastal zoning ordinance to facilitate farm worker housing. We put additional language in to facilitate second dwelling units. And then we also did the program for high-density residential development, which we refer to as RHD, and you've heard some testimony about the RHD sites. Essentially what the board did is rezoned 6 sites to RHD, which is high density for the unincorporated areas. It's 20 units to acre, and it's mandated by state law to meet your inventory. If you can't show that you have enough parcels, you rezone to this higher density. And we did that program. The board rezoned 6 sites for a total of 250 units, which are still available and not built, so we were able to bring them forward into our current inventory, and I'll explain that in a little bit. So that was a real key to this housing element. One other thing that we completed was zoning amendments to both the non-coastal and coastal zoning ordinances to clarify which zones allow special needs housing. It was something else that was in the state housing law that we addressed. And then what it does is it allows deviations from zoning standards to accommodate accessibility. Final slide on accomplishments, just in terms of meeting the inventory or the RANA needs. It's not something that the county doesn't go out and try to build the projects, but we report on how many units are constructed annually for each of the income categories. So what this chart shows above is all the income categories. These 3 here are the extremely low, very low, and low. When we talk about lower income, it encompasses all 3 of those categories, and you can see here what it's based on is the median income, which is determined by HUD each year, and we base it on the median income of a family of 4 in Ventura County, and that's how these numbers, they change and bounce around every year slightly, depending on what the median incomes look like. And then there's moderate and upper income, moderate or above moderate income categories. So what we do here, this is the previous housing element, was 2006 to 2014. These are the number of units that we were able to decipher from building records and put into income categories, or at the time at each year. And we ended up, here, actually these are what the housing need was, This is what the completions and the ones that were built and constructed in the unincorporated area. And so I did a comparison here of the completions versus the need. And the number of units that were not built. But again, this isn't anything that we're held to. It's just a reporting mechanism to see how well we're achieving the projected needs.
Ms. Finley, just the last one, the remaining housing need, it's how we add and subtract. If I stay just in the extremely to low income, it's not 186, it's actually a higher number. It's in the 200 range. If you take the 101 to 63 and the 80, just that level, that represents that we need to do more, to me, in that range. Do you see what I'm saying?
Yes.
Okay.
Yes. Those indicate, well,
It's a total, I get that at the end, right?
right. The totals don't necessarily mean a lot because there were actually 34 units that we just could not find any comparable sales or units or anything to put them into categories. But yeah, the lower income are very typically, you're right about that, the most difficult for us to achieve.
Okay, thank you. Sorry for the
And
interruption.
that's why these programs are geared towards high density, and density bonus is to encourage that type of development. Okay, now I'm going to jump into ongoing programs. These are, again, I'm not going to read them all to you, but you can get a flavor for what we do in our offices daily is some of these forecast updates, monitoring updates. We just do this routinely. It's all part of our work program in the housing planning world. So in the housing preservation, we actually bring in some other county offices that work on some of these things as well, like the building department and then the chief executive office, who works towards finding funding for rehab or administering funding, state and federal funds. Here's the rehab again. Some things that we do, housing opportunity and diversity programs. So I was speaking about the administering federal, state, and local housing funds, and encouraging, supporting other housing organizations. Housing opportunity and diversity. This is probably the most geared towards what the planning department works on, are these diversity and opportunity programs, the fair housing program, and then monitoring countywide construction demolition. That's something else that we do annually. These are some of the meatier ones, if you will. And these two programs are in the current 2006-2014 housing element, and we're bringing them forward. They've been directed by the board and were adopted in the last housing element, and they include this inclusionary housing ordinance, which is that we were directed to bring forward amendments that would require residential development projects of 10 or more units to provide lower income residential in their project. It includes affordable for every project that's bigger than 10 units. The housing impact fee, mitigation fee, has to do with employers who are bringing new employees into the area and assessing what that impact is on the housing market. And this would be, you collect the fee instead of having to have them do a housing study or an EIR every time they come in. So it's really intended to streamline process by having an in lieu fee or a mitigation fee that's already laid out. Okay, so those are not new. I don't know why this is doing this. It's humming at me. Okay, then I'll get to, we have 6 new proposed programs. The first one is that we're going to look for opportunities to support extremely low income, very low, and low income housing construction and rehabilitation. They're going to be promoted to the development community by updating and maintaining counties' websites. There are some programs that exist, and you've heard that a lot of these funding sources are kind of drying up or becoming very minimal. So, they're more and more critical, except there is less funds available, but we're going to continue to try to promote those and then to prioritize them to serve extremely low income. That was something that the state specified they wanted us to add in the provisions about extremely low and prioritizing it that way, because it's just, it's equated to like the farm workers. Their incomes are considered in most cases extremely low. Then we were proposing in the second program here to consult with the farm worker housing organizations and review our development standards that apply to farm worker complexes, and to see if there's anything we can do to facilitate that processing, because that's been a valuable piece of our housing inventory, is something that is probably most appropriate for the unincorporated areas as far as density, and trying to get constructed low-income farm worker housing. The third program here is to update. We do this, it's an ongoing program, to update brochures and website information, just so it's always current, to facilitate people who want to develop residential projects. And another one here, the County Executive Office, has been continuing to administer these loan and technical assistance programs. They wanted to add this one in because it's something they do, but they wanted it to be acknowledged here as something ongoing and that they're going to continue to do. And this, again, goes into that chapter or section 3.4, which is about employment and commerce. So this is the only one we touched in that section. And then here are two more that were added at the request of the state when we had our review. Is to update brochures for rehabilitation and for funding opportunities to help people stay in their homes and to rehab their substandard houses. And then the last one is to encourage and support development of lower income housing for extremely low, very low, and low income on the RHD sites. And that's something that we're going to support because we're doing this through a ministerial process, so we wanted to acknowledge that we did this program and that it's there and available as a program. So next, I'm going to talk a little bit here about the Regional Housing Needs Assessment, or the RANA, and its process and where these numbers come from. So the Southern California Association of Governments, or SCAG, is responsible for distribution of the numbers, and they're based on projections, and they do it. They get numbers and collaborate with the state, and then they bring them down to their region. And SCAG is actually the largest metropolitan planning region in the nation, which is pretty incredible. And somehow we got rolled in there, and there's 197 jurisdictions. And anyway, that's a whole other story, but I just think that's an interesting point of fact. And so they delegate and they determine the number of units for each jurisdiction to accommodate in their housing element. And this is how it relates to our inventory. And then they determine the housing requirements for each income group as well. So those income groups are all spelled out for us. So the distribution process, I mentioned earlier that they approved their run in October 2012. We got the numbers and we said, whoa, these are a little higher than we think we can meet in our housing element. And so we participated in the revision, request, and appeal processes that are afforded by state law and administered by SCAG. And we were actually the only jurisdiction that was able to get our numbers reduced. So we spent a lot of time on that last year, and it was a big deal because it's made us able to meet our inventory. The original number was 1,410, and then the current number that we ended up with was 1,015 units. And so that, again, means we can meet our inventory. So this is what it looks like, the kind of raw numbers, if you will. These are the income categories, and this is based on the 2010 median income for a family of four that's delineated by HUD and HCD annually. I use the 2010 median income because it ends up being the same as 2012, and our whole analysis was based on that. So it's 2010 or 2012. We found that out after we had originally published this. So the need, if you add these up, these are the new numbers, and the total lower income units is 414. You can see them broken down here. And then the moderate income and upper income. And that's what our inventory talks about, which is section 3.3.7 of the land use appendix. So now I'll talk more about the inventory. And the inventory is the amount of vacant or underutilized land that's available to meet these identified needs during that planning period. Again, the lower income household categories are the hardest, most difficult to demonstrate. And due to this RHD rezoning, we can demonstrate the inventory. Let me see here. Just for, let's see, for on this slide, I wanted to tell you this is shown in Exhibit 3.2, and again it's section 3.3.7. And there's a chart that shows how we came up with these lower inventory numbers, which is 541. It's comprised primarily of the RHD sites, which was 250 units. The Piru expansion area that was approved several years ago, there are 5 units that are lower income and have not yet been built. Cal State Channel Islands, their student housing, we're able to categorize some of their units, and because they're in the unincorporated area, we're able to use those in our inventory because it's a need in the unincorporated area, and that's 110 units.
So we made it, we made a determination that student housing qualifies for the low income?
Yes.
Okay. Talk to San Luis Obispo County, will you? They don't think so.
Well,
just a little sidebar.
The state has accepted our numbers, so that works for us.
No, I personally agree with you. Yeah.
And then farm worker units, we had 8 units. We have an approved farm worker complex out at Limonera that's, let's see, I don't have the numbers here. Oh, and I misspoke earlier. We did have one application for density bonus last November by CEDC for a 24-unit project in Piru. And so we were able to use that because it's an active affordable housing project, 100% affordable, and that's 24 units. So all told up, we ended up with 541 units, and the need, you can see if you total these together, is 414, so we actually have a slight surplus of available vacant land or underutilized land that could accommodate our lower income needs. Then the moderate and upper, you can see there's a huge surplus, and that's very conservative because we even took out all the open space in ag and rural. At the request of HCD, they said, you don't even need to include all that. So they said take them out because you have to list every parcel number in the back of your housing element. And they said, so go ahead and take those ones out. So this is a conservative estimate for the moderate and upper. Okay, that brings me to these other updates that are tied in state law to the update of the housing element. And for some reason, you know, they've found that housing elements are updated or have been updated more frequently than general plans. So things that are important, the legislature finds it important, they tie it to updates to the housing element. The first one is actually related to housing. And this is called SB 244, or the Disadvantaged Communities Bill. And in October 2011, they passed this legislation that each city or county must identify any legacy community, and there's a definition for that within their boundary that is a disadvantaged community, and it's all defined in state law. They have to provide analysis of water, wastewater, stormwater drainage, and structural fire protection needs or deficiencies.
Just a second.
Yes.
This was one of the general questions that I had, the legacy community. How is it defined?
Okay, it's a community that's...
But it's a state definition?
Yes, and I believe it's, you know, I'm not sure if I did this quite a while ago, but I think it's 50 units that, or they've been there for more than 50 years, and it's 10 or 12 or more units. And that's the legacy definition. And then the disadvantage has to do with the kind of the findings, but also the income levels in the community. It was quite a research project. So we have to deal with the ones that are within our boundary, but if they're in the sphere of influence of a city, and I'll get more to that in just a second, then that city has to do this analysis for the communities that are within their sphere of influence. And I'll show you what that means here in a second. So we have to provide this analysis and any funding mechanism that can make extension of these services and facilities feasible. So in our analysis, I found that there was the Satakoy community, the El Rio community, and then Piru that met these definitions. But because Satakoy is in the sphere of influence of Ventura, that went to them, and because El Rio is in the sphere of influence of the city of Oxnard, that was their responsibility. So I've done this analysis for the Piru community, and in a nutshell, we found that there were no significant infrastructure deficiencies. Recently, the Water and Sanitation Department had a whole upgrade to the treatment plant. There's plenty of capacity there. And then the Waring Water is upgrading their facilities, and they have capacity to serve water through the groundwater basin. So this is found in Exhibit 3.2 in Section 3.3.9. So it's become part of our land use appendix. Okay, this is the second Senate bill that was passed, 1214.
Hold on just a second.
Yes.
Could we just, since I did ask the question, I would.
I found the exact definition for legacy community.
Great, thank you.
Didn't mean to interrupt.
No, go ahead.
It means a geographically isolated community that is inhabited and has existed for at least 50 years.
Okay, with these problems, with these infrastructure
We have to do the analysis.
Well, that's just the definition.
The infrastructure. That's just the definition of what type of community.
Okay. It's just a weird name.
It is.
Like
50
that's
years.
what you leave. That's what you leave. That's your legacy. That's shameful.
They could call them antique communities or something.
Okay. Thank you. I appreciate that.
Okay. So this is the second one, Senate Bill 1214. And this was passed in September of 2012. And it pertains to the updating of safety elements. And it indicates that honor, or upon the next revision, the housing element honor after January 1st, 2014. But it was right there, and we're not going to be updating this for a while. And in our last cycle, there was actually another bill that asked for updating of safety elements, and we did most of the work already. So I just re-looked at them, and we did some additional updates to the name of documents and the CAL FIRE versus whatever the predecessor was. We updated the names of some of those organizations and documents primarily. And one of the bigger things is that they want you to address the risk of fire for land classified as state responsible areas and very high hazard severity zones. And so we had already done that and updated our map to the most recent map that's available in 2011. And so that's already included. But we did some additional, just very general updating. What that included, these are found in Exhibits 3.3 and 3.4, and that's what constitutes our safety element. It's the goals, policy, and programs is in Exhibit 3.3 for safety, and then, or hazards, and then the hazards appendix. And I did this, of course, in conjunction with the county fire department. So this brings me to public outreach and hearings. Here's a summary. All of the comments we've received are summarized in Exhibit 7. As I stated earlier, again, we had this pretty much a similar process as with the density bonus. You can see that we did the workshops. We posted the draft in January and February, and we had an online housing survey actually for the housing element. That's also included in Exhibit 7, the results of that. We met with our housing advocate, and we had a Board of Supervisors hearing on February 26th. So at the board hearing, there were some comments that I wanted to address here, and they have to do with mobile home parks. I'm not sure if they'll answer your questions or not, but
as long as we discuss it, that's all the law requires.
Okay. The board recognized that the mobile home parks are an important component of the county's affordable housing inventory, and they requested that staff consider possible ways to protect the existing mobile home parks. And it was kind of a broad general direction, so we looked at it at that level. What I found is that the local government has very limited authority unless they own or operate and maintain the parks themselves, and that they're actually regulated by the state, HCD again, and not by zoning. The applicable county regulations that pertain to mobile home parks are, we have a mobile home park closure permit requirement and rent control ordinances, or rent control ordinance, mobile home park rent control ordinance. So I took it from these two perspectives of closure. The county records don't reflect a closure problem. We had one permit issued in the last 10 years where there were 3 spaces taken out of a mobile home park because they were zoned commercial and they reverted back to commercial. And that's the only one that we have in our records or that anybody can remember. That was a closure in the unincorporated area. We determined that the closure issue is adequately addressed by Article 17 in our non-coastal zoning ordinance because this closure permit requires a public hearing and a survey, and it protects the mobile homes from unreasonable evictions and undue financial hardship, and it recognizes the rights also of the park owners. Then with regards to this conversion issue, again, the only conversion I guess we saw was that these 3 units were taken out and converted to commercial use, and that's what our records reflect, and the permits or requests that we have. The way they would be converted is through approval of a subdivision, so that it's like a condominium subdivision, so they become owner-occupied, and then they come out of rent control. Then this is where the survey is required, and a majority of the residents have to approve of it. And the local jurisdiction's recent legislation indicates that local jurisdictions must consider the survey results in their deliberations to approve or deny the subdivision, so it has a strong influence on the decision. And then the other way is if the owner opts to sell their unit to the park owner, then it comes out of rent control and could be converted.
We have 2 questions up here. Commissioner Rodriguez.
On that issue of conversion, can you update us on the status of the mobile home park in, I guess, Miners Oaks area on Woodland off the highway? That it seems to me that we're going through that issue several years ago. Do we have a disposition on that one? What happened?
Do you want a status on that particular mobile home park and where they're at in their development process?
Yes. I seem to recall that we were going through a conversion, or that there was an applicant there to do conversion, and there was some degree of opposition, obviously, from some residents. Did that ever proceed? I don't know if you can tell me today, and I don't expect you to, but...
Okay. We'll look that up and get back with you. I don't recall that.
Thank you.
Okay, well, that takes me to my question that I asked you earlier, because part of the density bonus issue was condo conversion, which your staff report specifically said apartment. But since that's the process that a mobile home park would follow, is the condo conversion, some bright young lawyer is going to say, we're going to follow the same process, and when we do that, we should be available for a density bonus. All right?
Okay.
Even though I know in the staff report, pages 14 and 15, you had a whole conversation about that. So if, I just going to put that one out there for you. Because when you go, because we use the terminology condo conversion, and that we've used it here. All right. So I'm just saying, there's an open door in a gray area, in my opinion. So it may be something that you want to visit when this moves forward to the Board of Supervisors.
Right.
Okay. Because you're using the same languages, same situation. So if I use the condo conversion program to go from mobile home to owner occupied, and I meet the other criteria, do I now get the incentives and the density bonus? Okay. See what I'm saying?
And we'll have to get back to you.
Yeah.
to that one.
Yeah. No, take that one forward to the board.
My understanding of the conversion is they put a map on it from a mobile home to the condominium, but
Right.
I don't know.
No, I
don't
know.
the
That's
answer.
my point.
Okay.
So I just want to let you take that one forward to the Board of Supervisors. Please continue.
Okay. Okay, and then one more issue pertaining to rent control is we have the mobile home park rent control ordinance. And this has limitations on the amount that the rent increases can go up each year. They're tied to Social Security increases. And then it also recognizes the need of the park owners to receive a fair return on their property. Oops, wait a minute.
Just one point on that. I
missed
noticed
one.
the statute regarding
Sure.
it's from an apartment to a condo.
Right.
The statute specifically says that.
Yeah.
So I can look at it, but I wouldn't think it would apply.
Well, let's just say I'd like to be in front of the argument instead of behind it when
Yeah.
you get to that point.
Okay.
Because I hear what it says, but if we're going to use the same process, if we can stay ahead of that issue, I guess is what I'm
Yeah.
asking for. Okay, thank you.
I mean, this is an area that is predominantly, if not exclusively, mandated by state law. So if that would be required, we wouldn't have any flexibility in changing that one way or the other. But I'll look at it and we'll try to get a definitive answer.
Well, I'm just saying you got all the elements, low-income housing, condo conversion process. Why am I not eligible for the density bonus or incentives? So that's kind of where my thought process is. Okay.
You mean if you're converting
Right, the mobile home
to an ownership?
So we're going to use the condo conversion process. That's what it's called. And we said that's the same process for apartments. Now am I eligible for these incentives and bonuses?
Well, it seems to me they're individually owned. So you would go from renting your mobile home to owning it. I don't think it has any impact on the developer or the owner of the entire park. But we'll look at it,
Yeah.
see if it applies.
Okay, thank you.
Okay, this next slide, and my last one on mobile home parks, talks about preservation of senior parks. And this is a brand new issue that was just brought forward to us last week. It's not something that previously we were directed to look at. So we don't have a lot of information on it. In fact, we don't monitor the occupancy because we don't regulate them in unincorporated, except in reference to the closure permits and the rent control. So this was a recent discussion. It just came up this week. The city of Ventura adopted it. It's something that we were kind of asked to put out there and see, what you think. But I don't really have a lot of information or data to make a recommendation. What we could do, however, is investigate the issue and options under a new program in the housing element. If you thought it might be valuable to forward that to the board, that recommendation, that would be up to you. But I don't have any draft language because I haven't had a chance to look into that. But I didn't want to not include it. Let's see. And then I included a map just so you could see where these are the parks in the current parks in the unincorporated areas. And you see the majority of them are here up on the 33 towards Ojai, the little red dots, and out, they're scattered out here in other areas. But we have, I believe there are 26 parks, and one is a senior park that came in and is not under rent control in like 2004, and that's the last, I think, new park that we've had developed, and I believe that's in the Oakview area. Kim shaking her head. Something else. Okay. And then the last issue that came up at the board, well, we discussed this at the board, and we've had a change in this one. I indicated earlier that we primarily look at Chapter 3, because Chapter 3.3 of the goals, policies, and programs, because that's what pertains to housing. We have a couple of policies that pertain to jobs and housing balance in Chapter 3.4, and we had gone through and done some edits to try to clarify things, and there was one that was done to a policy in this chapter where we added in language about oil and gas and mining to try to clarify the types of industrial uses that should be prioritized under this policy. There's a full explanation in Exhibit 3.2 under Chapter 3.4. And what we realized during the hearing, we had speakers come and say, well, why isn't agriculture included? And at the time, it's like, well, that seems like that might work. So we went forward with that. And when we reevaluated it, that section pertains to existing communities. So the edits we originally proposed didn't really fit, and they didn't belong there. So what we're doing now is taking that out. And because it became up at the board hearing, we wanted to address it. And so it was, transparent that we're not trying to not do something we were directed to do, but this is why we're not, is because it really doesn't fit and it doesn't pertain to the housing element.
And this section has to do with that IOD, or no? That index of dissimilarity, the jobs housing balance?
It has to do, that section does, that's why we include anything in that section, but this particular policy, it's in the goals, policies, and programs, and it talks about that industrial development shall be located within city or existing unincorporated areas. Oops, wait, that's the wrong one, sorry. 342, no, that's the right one. And industrial parks that have the necessary public facilities and services to support most industrial development, and we added in there references. There's an explanation on page 10 of Exhibit 3.1. But what our recommendation is that we're not changing the current language. We're leaving it as is because our proposed revisions don't really belong there. Okay. So last but not least, again, our CEQA document was an addendum to the previous EIR that we prepared for the 2006-2014 housing element EIR. And our findings, again, were that there was no substantial evidence to warrant preparation of the subsequent EIR MND. There's an analysis that's included, and that is included in your packet as Exhibit 5 for the housing element addendum. As far as the safety element updates go, they're exempt from CEQA pursuant to the section indicated there. And then to the recommendations. Same recommendations, that you adopt a resolution certifying that you've reviewed, the board has reviewed and considered, and that you've reviewed and considered the staff report and all of the exhibits and public testimony, and that we recommend approval to the Board of Supervisors. And that's my presentation.
Any questions of staff on the housing element? I know you had a bunch of questions.
Yeah.
Do you want to continue public testimony?
Okay, I'll go. The 2006-2014 housing element was completed in October of 11. And like all the cities in the county, everybody was late as all get out. And we're here, and if this goes through, you'll be in the streamline process. That's quite a jump. Congratulations.
Thank you.
Good template that you worked over for a number of years helped out, I'm sure. On page 82, I was advised by my partner over here that Mr. Leo Molitor lives in infamy as a District 1
Yes, I'm
planning
sorry
commissioner.
about that. I recognize that I
know Leo would
didn't
appreciate
update that yet. Yes. I will update that before we go to the board.
Now, did I get this right? The housing impact mitigation fee, that's not an in lieu fee, like inclusionary housing in lieu as opposed to actual units?
Right, they're two different things. The impact fee is actually related to impacts on the housing inventory or market, if you will, by employers who bring in new employees that are going to create additional demand for housing. And the way our environmental assessment guidelines read currently, if they're going to have more than 30 new full-time equivalent employees in this new business, they have to do an EIR on the housing issue. And so this fee would allow them to say, yes, we're going to have 50 new employees, so we need to pay the fee for the incremental change, or whatever the study ends up indicating. And it's intended to try to streamline that environmental process for housing issues for new employers. The in lieu fee is a separate issue. Right. It's when we have inclusionary housing, if that gets adopted and they're required to, say, provide 15% affordable housing units for every project over 10, then instead of building units, they can pay a fee that is supposed to go into a fund for the construction of affordable housing.
So does the county have an in lieu fee option?
We do not yet, and those programs are for us to develop those programs and bring them forward for approval. So you would see them here as we put them together before they go to the board.
Okay, thanks.
Nora, you have questions at this time?
Yeah, the section that talks about the 15% density bonus for 100% affordable projects, did the board direct you on that at all, or was that just as a function of working with the public?
The increase for 100% affordable projects, yes, that was something we developed in conjunction with working with the public. That was not directed by the board.
Okay, is it going to be a surprise to the board?
Probably. I don't know that it'll be a surprise, but it's all included here. It's something new, yes, it's something new. But I also want to point out, with regards to that issue about increased density, on the RHD sites, this is kind of in response to the earlier dialogues, the RHD sites, they already get 20 units to acre ministerial, and density bonus allows them up to 35%. So they have the opportunity for increased density already. And what they're asking for is us to do the additional 15% up to 50% density bonus on those sites. And our whole reasoning for not doing that is found in, I think it's page 17 of Exhibit 7. We have a whole list of reasons why we don't think that's a good idea.
I hear you. Regarding affordability categories and how it functions as a percentage of the median income, and which changes all the time, so it's kind of like trying to mount a horse that's running. What is the effect of these ongoing, usually increases in median income? Because you're working with figures that are pretty recent, 2010, but there are new figures for 2013.
Yes. Well, the effect is just that we have to kind of recalibrate, and we look at our building completions files and the neighborhoods, and And if we can, we use real sale prices and stuff like that just to measure, and that's the best we have to go on. That's what HCD requires, that we verify what assumptions we use to put them in categories.
Yeah, so when does the clock start on a project? Is it when the application is made, when the application is complete? Does it have an effect at all?
You mean when we count them?
Yeah.
As being a completion?
Yeah.
It's when they get their final building permit.
Okay.
So that's why we were able to include the Limonera project that's not been built yet, and some of these that are in the mill, and we put them in our inventory because they have real applications. Cal State Channel Islands has units approved to be built. But
Is this a problem?
They're not built or occupied.
Is this a problem? I mean, is this just the nature of the beast? Does this present a...
All of these assumptions are included in the land use appendix that we use for each type of product, if you will, and that went to HCD, and they approved our methodology and said this is kind of what the jurisdictions do generally. So...
And one thing also that I just wonder, because I don't know enough about this, is there a category after above moderate income? It's funny to me that because there's a lot of houses being built for people who are quite comfortably above moderate income.
Right, and that's why the inventory showed tens of thousands that, there is a lot of that product.
But those do not...
There's no differentiation after, I think it's 120%? Yeah, above 120%.
And so all of that development is not counted in reaching these goals?
Not all of it. Just we exceed that typically for the upper income or the above moderate income. It's used both ways. That's 120% and above. We typically exceed that in the number of units that are built during a planning period.
Okay. One thing, just reading through this on page 131 of our staff, packet, it talks about inadequate landscaping. What is that?
Oh boy. Can you tell me?
It had to do with the age and physical condition of existing housing stock, and it just was one of those things that I don't know what it is, so it just makes me stop and go, I don't know what to do with this information. Does that mean no landscaping? Does that mean the landscaping is overgrown? Does that mean the landscaping is all dyed? Does that mean it's a lawn and it doesn't fit with the 21st century? What does that mean?
Well, I'm not sure exactly where you're finding that, but...
On our packet, it's page 131, and it's under item 9, age and physical condition of existing housing stock. And if you can't answer, I won't hold it against you because it doesn't...
I think I'd have to look it up and...
Do you know what exhibit you're on?
Look at the context. It's probably in the land use appendix, right?
I'll go back. If I had a paper packet, I could just thumb back. But instead, I have to use this thing and slowly go through. So I don't know.
Yeah, my exhibits have the document numbers on them.
Moving forward, if you don't know, it doesn't matter. Another thing that caught my attention was this definition of severely overcrowded being 1.51 to a room. Are those non-related adults? I mean, are kids sharing a room severely overcrowded?
I think it's per room. It's not per bedroom.
Uh-huh.
So they're talking about the whole house having over 1.5 person in every room of the house. Does that make sense?
Does that include kitchens, bathrooms? What's a room? The definition of room is very nebulous. It's everything that's not a kitchen, right? Is a bedroom?
Well, They're
There
not
is a,
over
there
here.
is
I
a
think there's a
specific
definition
definition.
The occupancy standards are 2 persons per
Oh, oh,
bedroom.
uh,
2 people per bedroom at this point.
There's occupancy standards, I heard.
So Ms. Mappy-Ortiz is informing us that the occupancy standards are 2 bedrooms per bedroom plus 1. And
Okay, and-
so this is above and beyond that.
Okay.
Because it's considering all rooms in the house.
Okay, thank you. The flow chart for discretionary permit process, is that a new thing or is that existing?
That's existing.
Okay. On the meeting the needs of the homeless population in Ventura County and the problem with the camps and how they identified, that they were Ventura County, but it wasn't clear that they actually slept in an unincorporated area of Ventura County or whether they were in a city. Are these numbers large enough for it to make a difference for our county? Are the possible inconsistency in number or the unknown number, is it large enough for it to be a problem for us to meet housing needs for homeless population?
Are you asking about the discrepancies in whether they're actually in an unincorporated area or a city? Or are you just...
Well, what I'm referring to is that when there was a survey done, it was not possible to determine whether responses logged as county unincorporated were actually homeless people who slept in the unincorporated area on that given night, or whether or not they considered the unincorporated area their home.
Well, the homelessness issue is looked at countywide, and I think there's the program, the plans to endless homelessness are looked at more comprehensively. So, this is kind of a estimate based on the survey, whatever they found that day, and they update that, I think, annually. And so it's to look for trends and more general information and what is our need. So it doesn't really create a problem for us and as planners in the unincorporated area. It's a bigger ticket item for
Truly.
the countywide.
Okay, thank you. And a jobs housing balance, this index of dissimilarity.
Yes.
I don't know how big a problem that is now. In the go-go days of, 10 years ago, there was a lot of talk about a jobs housing imbalance. How big a problem is it now, and what are the trends? I see these numbers and these ratios, and the different areas. How are we doing with our jobs, employment and housing forecast? Do we look like we're going to balance out, or are we still going to have an imbalance?
Well, again, these are projections, and they're based on other studies that we gleaned information from, and I'm not an expert in this area. There's a projection here that by 2035, Ventura County is projected to continue to remain balanced with an overall ratio of 1.29 to 1, while all the urban areas will remain relatively consistent as shown in this table. And that's the best information I have at this point.
Thank you.
The chair had to step out momentarily. Are there any other questions of the staff?
No.
Okay. Why don't we take a minute and then reconvene when the chair comes back?
All right, we'll go, since we're still in the open public hearing, we'll go to people in the audience. And you know who's first, Lisa? And then after that, if Ms. Ortiz or anybody else would like to speak, just let me know. Lisa, name and address.
My name is Lisa Woodburn. My work address is 1672 Donlin Street in Ventura. I'm here actually today representing Lynn Jensen, who is out of the country, and she is the executive director of CoLab. And she is the one who made some comments having to do with the addition of agriculture as an industry in discussion of the changes to policy 3.4.2.6. Staff has reached out to Lynn to explain to her why this whole policy is being taken out of the discussion. However, I think because she is out of the country, I sent her the attachments and things, but I don't think she was really able to fully engulf everything, all the discussions and the information. And so she asked me to come to the meeting today and just speak on her behalf. Lynn appreciates Sakari had made contact with me to inform CoLab that the county is changing their mind on the proposed revisions to the general plan policy 3.4.2.6. However, Lynn is disappointed in the limited time she has to respond. CoLab would appreciate a delay in a specific issue before the Planning Commission to allow a meeting with county planning and our partners to discuss an acknowledgement of industrial uses in the county agriculture and open space areas currently supporting agriculture, oil, and mining operations. Production agriculture is a business with its assets in public view, and industrial uses like packing houses, sophisticated irrigation facilities, chemical tanks, tractors, trucks, etc., that need to have facilities located in these general plan designations. We believe that this county has a long history with an economic advantage from agricultural businesses that need to be recognized as such in the Goals, Policies, and Programs document. While the county residents benefit from the view sheds that agriculture provides, support of agriculture as an industry is imperative for its continuing success in a worldwide competitive market. Therefore, we are looking forward to participating in a larger conversation and to add our proposed language to the policy 3.4.2-6. Those are her comments. Thank you.
Hearing none, thank you for your patience.
Thank you.
Okay, I see two people. So, Ms. Johnson or Ms. Ortiz, any additional comments? Please. Name and address again, Susan.
Susan Johnson. I live in Fillmore. And this has nothing to do with the density bonus. This is a comment from my prior life as your Chief Deputy Agricultural Commissioner. I would just like to encourage, I said this at the discussion over the housing element, I would encourage you to make the housing mitigation fees as transparent and as fair as you possibly can. Just keep in mind that agricultural businesses in this area have other choices as to where they can farm, and you don't want to press them any harder than you absolutely have to. I understand, and they understand, I believe, about housing mitigation fees, but these people can pick up their operations and go to Watsonville, and I really don't think that's what we want here, is large operations who are more likely to bring in business and viable business to the county to take their administrative portion or their business portion to another county because our fees are higher than somebody else. So I would just encourage consistency and transparency with the other counties that grow similar things to us. Thank you.
Any questions of Susan? Okay. Barbara, anything you'd like to add? Again, name and address for our listeners in the audience on the radio.
Barbara McPhee-Ortiz, 1121 West 1st Street in Oxnard. Again, wanting to thank the staff. This has been seems like a never-ending process from one to the other, but we have really benefited, I think, and it is going to set the county on a good path for the next 8 years. So I appreciate both their diligence and also your diligence in terms of getting this through the process timely so they can take advantage of that opportunity. A couple of things just from Carrie's presentation. she pointed out a couple of programs that I think tie to our earlier argument in terms of the point with respect to broadening your ability with special needs housing. And I think that one of them was the program, I think it was 3.3.3.5, I believe it was either 2 or 8, was to prioritize housing for extremely low. And then there was another, what was it? Or maybe it was it was 3.3.3.52, and then the other one was 3.3.3.57, which again was to encourage a dialogue to try to figure out how we can get extremely low, very low income housing. So here on the one hand, your housing element is saying, look, we need this, let's figure out how to do it. And then on the other hand, we're saying, we're going to tie your hands. So that's the example there. The other thing, just to answer your question in terms of whether on the park conversions, whether they could take advantage of density bonus, I think the thing that would kill them is that in order to take advantage of density bonus, you have to have an agreement to restrict things for 30 years. Now, if you have a situation in a park where they're giving it to the homeowner to buy, why would you restrict it? So they couldn't meet all the requirements, even if they could make the argument, which I don't think they could, but that would be the one, how you say, stake in the heart that they couldn't do. The other concern with respect to mobile home parks and seniors, what we've had, I don't know, not so much in the county, but in the unincorporated area, but throughout the county with mobile homes, we are seeing senior parks dissipating into family parks. And the reason that's happening is because as seniors age out, want to sell their homes, they're having less and less ability. There's a lot of things going on. Parks are some of them, the hoops they put people through and the reasons they deny new purchasers, I'm seeing a wave of that where they're denying everybody because of their credit, even though under the law they can't. So that's the big problem. And maybe as we look at this issue for future, there may be some ordinances that can be put in place that will make it a little bit easier for a senior to come in and buy a senior lot or the home. If they can't do that, then we're really stuck. But anyhow, I think we've got a good housing element. It gives us a good guide to move forward, and hopefully we can get some results in the future. Thank you.
Thank you, Barbara. Anybody else? I know we have a new person in the room. If you want to, okay. Is there anybody else who would like to speak in the open forum? Going once, going twice. Third and final offer. Then the chair will now close the public hearing. Any additional questions of staff or clarifications, or would you want to deliberate? Remember, we have a bifurcated request from staff. So, discussion.
I'd like staff to respond to this notion that somehow we're tying our hands if we don't adopt the remaining outstanding issues that are offered by the housing advocate. Because I don't see it. So.
Commissioner Dukas, I don't believe we are tying the county's hands, because what we are bringing forward actually is a non-mandatory potential additional density bonus of 15%. And the only area that we're saying that would not apply to would be the RHD sites. The county processed RHD sites in a fairly unique way during its previous housing element. We did a full-blown project-level CEQA documentation for those sites, and we did an addendum to it as part of this process for the 35% additional density bonus. So someone can come in and they do not have to process CEQA, which is going to save them a lot of money. And they can also process on RHD sites using a zoning clearance. You can't do that with other types of major development in the county. So we've actually provided a major benefit on our RHD sites to prospective affordable housing developers. And I'd like to note that one of the problems with putting another 15% on there is, first of all, CEQA. We would have to undergo additional CEQA analysis for that. But secondly, it would make the process potentially non-discretionary, and that's not our goal. So it seems like the major step forward that the county took with those RHD sites could in fact be harmed if we brought into that whole process this additional 15% on top of the 35% that you can get with a density bonus by law.
I'd also like to ask, thank you for that response. I'd also like to ask staff to respond to the issue regarding waiting on this and what the repercussions would be if we decided to postpone this in order to get more input regarding agricultural or the appropriateness of including agriculture in these housing sections.
Well, the addition of the word agriculture was actually not related to the housing element. It was in a different section of the general plan. It's a section that relates to employment and commerce and industry. And what we found was that that whole section of the general plan only relates to industrial development in our existing communities. In other words, urban development. So including language related to agriculture or oil and gas exploration simply doesn't fit into that section and would be inconsistent with it.
And
so
what would the effect be if we decided to explore the issue even more? What would be the effect of postponing the Planning Commission's decision on this to another time?
The effect we would have a very negative effect on the housing element itself. And we have a very tight timeline for getting the housing element adopted into the state HCD. So if we were to delay that process, we would no longer have the streamlined review process for our housing element, which means the state would be opening up our entire housing element again, and we could be back here again looking at a housing element the state has already told us during a streamlined review process they're pretty happy with. So one of our big concerns about any delay is that we would have a big effect on our ability to obtain a certified housing element. And the state actually has some pretty unpleasant consequences when you don't meet deadlines.
And what are the consequences if we decided that we're not going to follow the state mandated guidelines regarding a density bonus? What would be the repercussion that the county would if the county didn't develop these density bonuses?
Actually, we're mandated by law to provide the density bonus. We're mandated by law to do it today. But what we lack today is a clear ordinance that staff can follow if we get a density bonus project submitted as an application. So in reality, the density bonus is in effect, but we need to have an ordinance that's consistent with the state law, and currently our ordinance is not consistent with the state's most recent changes.
Thank you.
Any other questions of staff? Rick?
I don't know if it's properly directed to staff or county council, and it's kind of a hypothetical situation related to an issue we recently addressed in the east end of the county that went forward. Is there any retroactivity to projects that have been approved and have not broken ground where it can be amended to bring in these upgraded density bonuses?
Well,
or are they restricted to what was approved and what was included in the EIR?
I guess as Ms. Rowan pointed out, the density bonus law has been there all along the whole time. We're not implementing anything new that didn't already exist except by putting it in our ordinance. As far as other projects go, I guess planning would have to look at it. Is this something that's still in a processing stage? Maybe didn't include it and want to amend their project, or is it already approved? I think you need more specifics on that.
Okay, thank you.
Any other questions of staff?
Yeah.
I have one. I'm not going
I
to...
got one.
Oh, I'm sorry. My apologies.
I've got an issue with the nonprofit low-income for ownership builders. And I'd like the planning group to take another look at that. But is that going to slow down the process you were just talking about?
Now, are you talking about the issue for the Habitat Humanity, whether we can apply density bonuses to 4 units or less instead of 5 units or over, right?
We've added anything else, for that matter.
Yeah, and I think that we can, that issue was just raised to us last night, so I think that we can work with county council and see if there's an issue. I would hate to do anything now because the fear of the unintended consequence, which is what happened with Ms. Jensen, where she came and we quickly reviewed the paragraph and said, oh, sure, you can throw agriculture in there, that makes sense, without going back in and looking at the whole lead in and whether that really made sense or not, right? So I am loath to, make a hasty decision, but I think it's an interesting point that was just raised to us last night and one that I would be happy to look at and then present those findings to the board if your commission would like us to look at that.
I would also like to note that there's 2 different ways to approach any changes that the Planning Commission would want to make to what we presented to you. The most difficult thing is, as Kim pointed out, is to actually make a change to the proposed ordinance prior to going to the board because we have a fairly tight timeline. But we can look at it and determine that before the board hearing. But the second methodology is simply to add it in as a program to the housing element itself. Anyway, I'm not sure that's an approach that the planning director would want to pursue, but I wanted to point that out to you.
Well, I'd like to make a motion then that... Oh, I'm sorry.
No, but the Robert's rule says somebody has to make a motion. No, the question I have, and it may be because it's okay, is, and it may be because I'm not feeling well. In my review of the documents, I didn't see any discussion on Measure A as far as policies and programs. Now, I know that low-income housing and things are categorically exempt, but I don't remember seeing that, and the reason I'm asking is because if we recommend this, it gets approved by the Board of Supervisors, it will still concurrently run with the existing Measure A, which terms out in, I think, 2020. So I may be wrong, but I don't remember any discussion saying this doesn't apply, the SOAR initiative.
Took me a while to get on the same page with you, and you say Measure A now.
That's
like,
right.
okay,
I'm having a hard time
you're
getting
talking about
the same page
SOAR.
with me.
So what was your question again? I'm sorry.
But I may have missed any discussion of at least addressing the Measure A as far as an ordinance and policy, because that obviously affects the housing element. But I know there's categorical exemptions for low-income housing and senior. So is that the reason it wasn't even introduced? Again, I may have missed it, so I apologize to you. It's not a deal killer. I just wanted to raise that issue. So, as it moves forward to the Board of Supervisors, I'd like to have that addressed. How's that? All right. Mr. Magai, you said you had a motion.
Yeah. I'd like to make the motion that county planning staff take another look at the density bonus criteria as it relates to low-income nonprofit housing developers for sale units without slowing down the process. Thank you.
All right, so what we have is a motion for the board staff to look at a density bonus criteria for the low income. Is that correct? I may have missed the last part of that.
Oh, button that's fixed.
So you're supporting the density bonus? Staff recommendations, I'm a little confused here, I'm sorry.
Say again?
Your motion, is it to support the staff recommended density bonus?
Yes.
Oh, all right. I have a motion. Do I have a second?
I'm not clear because
not either.
that's
Well,
not
well-
what you said. You confined your motion to just the staff looking at the Habitat for Humanity issue and didn't speak to the bonus
Okay.
density bonus.
Well, I meant to. Maybe I didn't.
Okay, you didn't.
So you want,
I want it,
okay,
and we're just dealing with the density bonus right now, correct?
right.
Or the whole banana?
So just 1 and 2 of the recommended actions.
Yes.
We're bifurcating. Okay.
Okay. Do I have a second on recommended actions 1 and 2?
With the inclusion that
Staff review.
that
Yes.
staff review that.
That's what I was trying to do.
Thank you. All right, do I have a second? Oh, we have a motion and a second. Discussion? Oh,
We have a second?
Yeah.
All right. Because of the timeline and because of how long that we've been in this process, I think moving forward with something that maybe isn't every last thing that could be done versus getting it perfect. It's like the perfect is the enemy of the good, and it seems to me that there's an urgency that we need to move forward with this, and I don't know what the repercussions would be if we didn't move forward in a timely way. So I can't support it.
Okay.
I think it's a topic that we could probably explore much more, but I also agree. I think we're never going to get it perfect. And I don't think we have the ability to go back now and have staff do further work on this thing. I think we should go forward, so I'm going to not support that.
Okay, since we have a motion on the floor, and so we need to vote. So those for it, vote yes. Those against, vote no. I don't see it, but I assume we have a 2-2 vote.
I think I hit the wrong button again.
So that counts as a rejection of the motion, since it's a tie under Robert's rules.
Do you want to just restate the motion about the habitat?
Yeah. And I'd like to make a motion that we accept the density bonus staff report as written.
All right. I have a motion to accept the density motion. Items 1 and 2 are recommended actions. Do I have a second?
I'll second that.
All right, wait a minute.
It's not work. There it is.
10 seconds. Okay. And as soon as the magic number comes up. Any further discussion? Hearing none. All those in favor say yes. Those opposed say no. Commissioner Onstott can abstain. I'm just seeing if anybody's awake out there. So we have a recommend to the County Board of Commissioners, Supervisors 1 and 2. We still have item number 3 in recommended actions. Commissioners?
Do you want to do 3?
Okay.
I would move the recommendation 3, A through F.
Okay, I have a motion to accept 3A through F. Do I have a second?
I'll second that.
Any discussion on the housing element as presented by staff and the motion? Oh. Did you click on the motion?
I have a motion on the floor, blank, motion in progress, and nothing's coming up.
We need to go back to
On the floor.
motion.
Okay. Sorry.
Kate, sorry.
I keep trying to use this thing on this.
Hey, I keep trying to use the mouse on the iPad. It's even better. All right, any further discussion? Not hearing any vote, yes or no? Recommendation passes. Thank you, ladies and gentlemen, for your input, your time, your energy, and your effort. We certainly want to thank staff for trying to make it clear. I think you've done an outstanding job, personally. All right. All right, moving on. Item 8, report by the Planning Director.
Thank you, Chair Wessner. I just want to briefly go over what's coming up on our tentative agenda. So we have meetings scheduled right now for October 17th, where we have 3 appeals in the same vicinity. And then we have an appeal of a planning director equivalency determination on October 24th. And then we had an item that was on December 19th, but that item has been moved to January 16th. And that is a Saticoy area plan update and a site tour. So we're going to arrange a tour for the Planning Commission for Saticoy. It's a update to our area plan. That looks like it's scheduled right now tentatively for January 16th.
2014.
That's
2014.
That's the hearing or the site visit?
That's a site visit.
January 14th.
Mm-hmm.
Okay.
Which one?
16th. January 16th, 2014.
I have it on the 16th on mine, on my
What'd I
agenda.
say? 14?
You said 14. I
So
think
it's
you heard me
16?
say 14, probably. It's in January.
It's in January. We have the date wrong.
January 16th.
2014.
14.
Goodness me.
And that is all I had. I think I updated your commission that the Grimes Rock Mine expansion project that you had approved on a 5-0 vote has been appealed by the city of Moore Park, and so that will be heard by the board sometime in October. And that's all I had, unless you had anything for me.
Okay, anything from the planning commissioners would like to introduce?
So, comment, just, so we're coming back on the 17th of October for the next meeting, so I'm clear on my calendar.
Yes.
That's new.
17th of October.
Okay.
That one just popped up, right?
Did it? It's on my tentative agenda as of today, and they're updated as items are put on here. You know, but when I was looking at it, I was going to see if I could move the 17th items to the 24th, if there's a reason why those are on the 17th, and if we can't just have a hearing on the 24th. So I'm going to go back to staff. It's on the tentative and see, you know, if there's a reason why we have a hearing on 2 weeks. And sometimes it's because of the availability of the appellants, but
Right.
I'll check to see if we can do that.
All right. All right. Any further comments from the commissioners? Hearing none, this meeting now stands adjourned.